The item 32
Item 30?
the seat was for the cities, but updated seat not available.
Yes, sir. The petitioner is already on interim lordship, so let it be after vacation.
It has been submitted that the updated CD in the matter is awaited, full stop. Mr. So-and-so appears for the petitioner, full stop. List again on 20th of January 2026. Interim order passed earlier shall continue.
Diploma.
Yes?
Yes, I beg to mention item number 40.
1440,
40.
yes?
I am not pressing this matter.
Why?
The person has been arrested. The anticipatory bill.
It has been submitted by the learned counsel for the petitioner that the petitioner has been taken into custody and therefore he does not, he is under instruction not to press this anticipatory bail petition, full stop. Accordingly, this anticipatory bail petition is closed on withdrawal.
CD will be returned, lordship.
The CD called for shall be returned.
May I please, Your Lord, I beg to mention item number 4, my lord.
4.
Yes, can this matter be taken after vacation, my lord, your opinion?
Let it reach, it is 2019, we'll have to do something on it. We'll have to pass some order on it.
Of this.
Please, I beg to mention item number 42, lordship.
42.
Not available.
Yes,
He has not been received, lordship.
it has been submitted that the CD in this case is yet awaited, full stop. Mr. So-and-so appears for the petitioner.
Interim was there.
The petitioner is on interim bail. Interim protection to continue till the next date of listing. List on
21-1.
21/1/2026.
Your Lordship, item number 36 may be passed over for a day. For the day, my senior is out of station. Interim bill may be continued.
There is some office note in this. Yes, Eba. How about 36 too?
Service is complete, lord.
Service is complete. Then wait for some time. We will not take up the matter today for disposal. Since the service is complete, we have to pass an order on that.
Already, lordship,
Wait for-
respondents are appearing.
Correspondence are appearing.
He is also received.
When do you want it?
Out of station.
When do you want it?
I'm not aware of it.
Before
On interim.
on interim. Optometer.
Hmm? He's on interim. The learned counsel for the petitioner has submitted that. No, it has been submitted on behalf of the learned counsel for the petitioner that he is unable to attend the proceedings today. Full stop. The respondents have, the respondent number 2 has appeared in the matter. The learned APP has submitted that the case diary is available. Accordingly, list this matter again on
It is available, lordship, so let it Friday or Thursday, lordship.
On Friday, he'll be here. It's Friday video. On so and so. Interim orders passed earlier shall continue.
May I please, Your Lordship,
Yes.
like mention item number 35. Your Lordship, updated CD was called, but same is not received.
It has been submitted that the updated CD call for has not been received as of now.
Lordship, interim may be extended.
Ms. So-and-so appears for the petitioner. The interim orders passed earlier shall continue. List the matter again on
The vacation, lordship, 21.
23rd of January 2026.
Okay, lordship, here the item number is 35. 33 is also connected matter.
Okay.
Different petitioner, same CD.
But 33, we'll have to inform him when he comes. We'll have to tell him and take it up on. Yes.
I plead to Lordship.
Yes.
I beg to mention for listing one regular bill application, Lordship.
Allowed. Acha, there is a senior bench. Why are you mentioning ki naha heri lagot patha nai jano? Below 7 years, above 7 years, below 10 years, above 7 years. Huh?
Here bench.
There is a senior bench. Why on this bench? Go to the senior bench and mention it. Yes.
Lordship, I beg to mention item number 20, Lordship.
20.
Yes, Lordship.
Yes.
It may be fixed after vacation, Lordship.
You are appearing for the petitioner.
Yes, Lordship. My name is not here, Lordship. I am appearing on behalf of S. Roman, Lordship.
On a request made on behalf of the learned counsel for the petitioner. Have you informed the other side? Have you informed the other side? List this matter again on
After vacation, Lordship, any day.
23rd? 23rd of January 2026.
Obliged, Lordship.
Yes.
Please, your lordship. Lordship, I would like to mention item number 30.
Hmm.
As engaged counsel is out of station, he could not come due to flight cancellation. Fix it after vacation.
It has been submitted that the concerned counsel appearing in the matter has not been able to reach Guwahati due to cancellation of flights, full stop.
Interim order is
The matter be again listed on, when do we have it?
Lordship,
Are you on interim?
yes, lordship.
On 22nd of January 2026. Interim orders passed earlier shall continue. Full stop.
Obliged, lordship.
Please, your lordship. I beg to mention item number 21 and 22 for withdrawal, lordship.
Learned counsel for the, why do you want to withdraw it?
I have no idea, lordship. My senior has
Please have the instructions why you want to withdraw. There are cases where two bail petitions are filed in different courts. If that is the situation, then we are not allowing the withdrawal. We'll take some other action on it. So kindly find out why you want the withdrawal.
Another pair for item number 24, lordship.
24 years.
Kindly adjourn for the day, lordship. CD is not there.
It has been submitted. The CD in this case is awaited. Accordingly, list the matter again on 21/1/2026. 21st of January.
Same pair for item number 28 also. sir. On
28.
behalf of KT.
Okay.
Can copy, Lordship.
The scan, it is there. Scan copy is there, but she wants an adjournment. She doesn't want to do it today. Although the scan copy of the TCR has been received, and a request has been made to take up this matter on some other day as the learned counsel for the petitioner is unable to hear. Full stop.
Okay.
Accordingly, let's this matter again on 22nd of January 2026.
Obliged.
Yes.
May I please your lordship? Lordship, I beg to mention item number 29, as my senior could not come due to some medical issues. To adjourn for the day, your lordship.
He has not been received, Lordship, so
It has been submitted that the CD in this case is yet awaited. Full stop. Accordingly, list this matter again on
19 January.
19th of January 2026. Ms. So-and-so appears for the petitioner. Huh?
Motion, Abby. You have to.
May I please, your lordship? When petitioner before your lordship, he is a counter agent over taxi, my lord. Yes,
Share taxis.
so my
Mm.
on lordship 27, one person Sahil came and started quarrel with the taxi driver, my lord.
Mm.
Then he interfered between the driver and the Sahil, my lord.
Mm.
Next day again she came, my lord, intoxicated condition, and he started quarrel again with the petitioner, my lord.
Mm.
So matter was settled. Yeah, after 3-4 days, police filed on petitioner, my lord, and now searching him without issuing any case, my lord, without issuing any notice, my lord.
You are the taxi counter person.
Agent, my lord, counter agent, my lord.
What do you
I-
say?
Also, we'll have to take the instruction if any FIR has been registered, because they have not annexed the FIR.
Against him.
There is no copy of FIR. So we will take instruction if any FIR has been lodged against him.
In the meantime, if he's picked up.
Only coercive action may be taken.
Huh?
In the meantime, coercive action may be taken.
Not about course of action. You go and you appear in the police station if they require you. If they're harassing you, if they're calling you, go appear and you may record your statement. You'll also know what is the FIR against you, what is the allegation against you. You can at least
Definitely, well, he will
come
appear.
back with an additional affidavit
Uh,
saying this is the FIR, this is what is against me.
Well, coercive action may be taken.
No, not about course of action. You go in and you
And
appear.
he-
If you are arrested, you will.
Otherwise, he will be arrested, my lord.
Huh?
Otherwise, police may arrest him. I have annexed some,
We'll give him an interim.
I have
at
annexed
this
some
stage.
orders, my lord.
Let him go and appear. Let him find out what is the matter.
My lord,
Because I think it is just a counter fight.
only dispute.
Fight on the taxi counter. These things, if you keep people behind bars, no. Heard Mr. So-and-so learned counsel paying for the petitioner. Also heard Mr. So-and-so learned counsel paying for the so-and-so. Learned APP seeks some time to find to take instructions as to whether any FIR has been lodged against the petitioner. So since no FIR has been annexed to the bail petition, full stop. The learned counsel for the petitioner has submitted that he is ready to cooperate with the investigation, if any, and therefore he may be protected. In the meantime, full stop. List again on when can you have the instructions?
After tomorrow.
List again on day after tomorrow to allow the APP to have his instructions in the matter. In the meantime, if the petitioner is arrested, he shall be released on bail on so and so, so and so, so and so. Petitioner shall also appear before the which police station? Who's
Distu-
calling you?
Distu police station.
Shall appear before the officer in charge, Dispur police station.
Tomorrow.
Tomorrow itself. Tomorrow itself. Full stop.
Problem.
Yes.
Copy will be,
Huh?
certificate copy will be required, my lord. So day after tomorrow, my lord.
What will be required? Copy of the order.
My lord.
You will have it in the evening, don't worry.
Oblige, my lord.
Just mention Lordship, he will appear before the relation to the incident on so and so Lordship.
He will appear before the officer in charge of the Dispur police station in relation to the incident alleged to have occurred on
27 and 28, my lord.
27,
And 28, 11,
27 and 28th of July 2025,
November, my lord.
November 20.
November 2025.
My lord.
Full stop. Yes.
Oblige.
You appear, you have your statement. इसको जल्दी करके निकाल लीजिएगा हाँ ये भी have this on my table at lunch this order huh yes sir.
Lordship, the present matter arises out of a contractual dispute, Lordship.
Hmm.
The FIR is at page number 9, Lordship.
Hmm.
The translated copy. If I may read, Lordship, with due respect, I beg to inform you that on 5/7/2024, I had handed over the possession of my Mahindra Bolero vehicle bearing registration number so and so to the accused person by accepting rupees 1,70,000. There was an agreement with the accused person that he would pay monthly EMIs to Chola Finance Company. The accused person has not regularly paid the EMIs, and more than it is actually 3 EMIs have remained unpaid. I have come to know from specific sources that the accused person has sold the vehicle to an unknown person without informing me. Presently, I have not received any information about the vehicle. I suspect that some other persons are also involved with the accused person. During the course of investigation, Lordship, the relevant agreement has also been seized by the police, Lordship. That is
Huh?
the agreement, sale agreement of the vehicle has been seized by the police. It is
Ah.
at page 14, Lordship.
That agreement is between you and the owner of the vehicle.
Lordship, yes.
So why did you not have it transferred to your name or buy it over?
Lordship, I was supposed to pay the due EMIs. I have
Huh.
paid 1,70,000 and I have paid around multiple EMIs. I have
Huh.
annexed some of the receipts at page 18 also, Lord.
Hmm.
So I could not pay some of the EMIs because of financial difficulties, Lord.
Mm.
So in my humble submission, it is a matter purely of civil nature, Lordship. And moreover,
Can you produce the vehicle
Lordship, I
before the investigating authority? You produce the vehicle before the investigating. We are giving you an interim. Produce the vehicle before the investigating authority, and if you can produce the vehicle, you will be protected for your statement
Lordship, I may be allowed to have my statement recorded at
along with the vehicle.
Lordship, the vehicle is with one other person, and that person is an accused in different.
Then we'll ask for the CD.
But Lordship,
Before buying the vehicle, how could you sell the vehicle?
no, I have not sold it.
Ask for it 3 days.
No, I have given it to another person on rent, on
Ask it
rental
back.
basis.
Ask it back because there is a
He
police.
has fled, Lordship. He is accused. He has fled with multiple
take down.
vehicles.
Heard Mr. S. D. Leonard counsel appearing for the petitioner also heard
Okay.
the Leonard APP. Yes,
Lordship, I can show documents that he is an accused in 2 other cases also.
could be.
On same allegations. One
Could be.
FIR is also there about him fleeing with a vehicle.
Those are not before us. You have not given it into this. You have not taken that ground in the bail petition, have you?
I have, Lordship. I have.
That it was given to someone else on rent
Yes,
and
yes. I have
it's a
stated-
private vehicle.
Yes, Lordship.
It's a private vehicle and
Yes.
you are giving it on rent. Another, I think you'll be opening a Pandora's box.
So He had to, Lordship, give me some EMIs also, monthly rental.
No, this system is not working out.
But otherwise also, Lordship, the allegations, the maximum offense is punishable by 7 years, Lordship.
Yes,
So as per section 173(3) of the BNS, there has to be a preliminary inquiry.
yes.
And also there has to
That
be
is
a
what we will
notice-
ask them if there is any preliminary inquiry. He'll come back.
Lordship, for the case
When?
that
Section 41,
Huh? Any day.
from this one.
section 41A notice, Lordship, that is now section 35(3) of the BNS. Under, as per the Arnish Kumar judgment, that has to be there, Lordship, in
Hmm.
cases of this nature.
We'll have to ask for the records to see whether that was there or not. Only
That
then
is
we can
not
say
there
this is an AB.
Because my wife has also been arrested, even though she
Huh?
is not connected with the FIR. My wife was already arrested.
This is an AB, I think.
Yes, yes.
We'll consider your wife's case when you bring up all these points. No difficulty.
No, they are not issuing notice under section 35(3).
So that we will consider in your wife's case, not in your case. We are saying that if you can produce the vehicle before the IO along with your statement, the vehicle will not be seized. You will not be put under arrest. We will put up both the conditions. No difficulty. Produce the vehicle.
I will try my best, Lordship, but
The interim will only be to the extent, will only apply if you can produce the vehicle or you can show that it has been stolen and you had given it to someone or you had lodged an FIR that so and so person.
I could not
Has
lodge FIR,
run-
Lordship.
Why?
I could lodge FIR because I cannot go to the police station.
When did you
without
give it to
FIR.
him? There must be one statement here. When did you give it to him?
Lordship, I have made a statement.
Where?
Para 3, Lordship.
Paragraph 3.
After paying, read, Lordship. That the petitioner
Person
is,
to, Who is that another person?
that is one Anuj Kumar Bora, Lordship.
Where is it?
Lordship,
Where is it that the person has, when did you enter into an agreement, that agreement when you
there
entered
was
into
no-
him?
It was an oral agreement, Lordship.
When did you enter into an agreement with him? When he is an accused in other cases, did you also lodge an FIR that my vehicle is with him? Please bring back my vehicle also. Nothing of the sort. Not working out, sir.
Go and lodge an FIR, that I can assure, Lordship, but I cannot appear now. If I appear, then I will be arrested because my wife was also arrested. Let my statement be recorded, Lordship will produce the CD if there is
One more
material,
thing,
Lordship.
Lordship,
Why has your wife been arrested, huh?
case Supreme Court judgment also, Lordship.
Mm.
Which will issue. They should approach the concerned court below, Lordship.
Below.
Then only come to High Court. That also has not been complied with, Lordship. The CD come, Lordship.
We'll have it on Friday.
Prior-
We'll have it on Friday. You also have what you need to do. Find out.
We'll produce the.
Thursday.
Yes.
Yes, Thursday also, no difficulty.
File an affidavit also to bring.
File whatever you want to, but unless you bring something on record to show us some extent of your assumption of innocence on your part.
Lordship, I will file.
With these statements, can we say every person will come and say, I've got it? We'll be stopping the entire investigation like that.
I will appear, I will cooperate with the investigation. I'll try and facilitate recovery of the vehicle also.
Give us something where we can
I will-
consider your case. Yes, heard Mr. Asdale, Learned Counsel paying for the petitioner, also heard Mr. So-and-so, Learned APT. It is stated by the Learned Counsel for the petitioner that the vehicle in issue had been rented out to another person. And the said person has also absconded with the vehicle, full stop. Therefore, the petitioner is not involved with the involved in the allegations leveled against him in the FIR stuff. The Learned PP has prayed for calling of the CD. Since although there is an agreement, the vehicle is yet to be traced off and stuff. List this matter again on Thursday. When is Thursday? 18th of December 2026 to enable the additional PP to have his instructions in the matter. The petitioner would be at liberty to file additional affidavit if so advised.
Much obliged.
Item 4. Please, Your Lordship. I second adjournment in the morning, my lord.
Why from 2019?
My lord.
State is a formal party. What are you? Against
Madam,
conviction,
there is a
disposal of
already
appeal
nine
against
point two
conviction for
percent.
non-appearance of the counsel is bad in law.
Yes.
Yes. You are appealing for? Respondent number 2.
But one thing kindly see, my lord.
Allegation was of what? What did he do?
34, kindly see, my lord, page 34.
34.
Yes.
Yes.
And 35 million, the order dated 19/8/19.
Hmm.
This has been challenged, my lord. This has been challenged in this case, my lord. My lord, let the matter be, my lord, decided by appellate court. Because, my lord,
He is agreeing to your revision.
yes, my lord, I understand, but let the matter come after.
Huh?
vacation, my lord.
Because
I have
at best we
instruction.
can only ask it to be remanded back.
Yes.
We cannot decide the issue.
Yes, my lord, that is,
He is agreeable that if it goes before the appellate court.
but we have to obtain instruction, my lord. Just on reopening. my lord.
Suppose your petitioner says no. Then what happens? We decide it.
No.
If we decide it, what do we decide?
Today
In
is
your
today-
favor, back to the
it's a
court.
long time today is come for the first time, my lord.
Okay, we'll give you some time. When?
Friday, my lord. No, can it be on reopening, my lord?
No, it is not in the next
Well,
Friday.
any date.
These are motion days. We are not taking up these old matters. Because if you are in a hurry, you would have mentioned it to brought it on record. Huh?
2019.
Yes, you also did not take any steps, although there is a stay. Is it not? Then.
That may be.
Hmm. We'll have it around 19th of January.
Yes.
19th of January. Mr. So-and-so appears for the petitioner, Mr. So-and-so appears for the respondent number 2, Mr. So-and-so appears as the additional PP. Stop. The revision is against the order dated 31/5/2019 by which the appeal filed by the petitioner had been dismissed due to non-prosecution, full stop. The learned counsel for the respondent number 2 has submitted that he would have, the respondent number 2 would have no objection if the matter is remanded back to the appellate court for a decision on merits, full stop. Mr. So-and-so seeks time to have his instructions from the petitioner, full stop. List the matter again on 19/1/2026, on which date Mr. So-and-so shall submit the instructions received by him, and in absence of the same, the matter will be taken up for disposal on merits.
Published.
Yes, sir.
As per the office note, Lordship, the records of the trial court have not been received. The revision is against the concurrent conviction of an NI Act, Lordship. It has already been admitted, so the records are required for the final hearing to take place. As per the office note dated 9/12/25, the records were called from the trial court. Same has not been received by any section.
Also, Lordship, as per the last order, they were asked to deposit 20% of the amount. Their contention is that they had deposited 20%. However, when we filed the application for withdrawal of the money, we were given the liberty to withdraw the money. So we had filed application twice on 2 different occasions to withdraw the money. Trial court records were not traceable. That is the reason we could not withdraw the money. And we are not even sure whether the money was
That is
deposited.
up to the trial court because
Because-
we had submitted the.
Was the money deposited?
Yes, Lordship.
Some receipt, some order.
Lordship, the trial court has already passed an order, but I found the receipt, Lordship. They could
What
not
was
trace the
what has
file.
the trial court said?
That they could not trace the file and they are not sure. Without the file, they cannot be sure whether the amount.
So was the receipt. Heard Mr. So-and-so learned counsel appearing for the petitioner. Also heard Ms. So-and-so learned counsel appearing for the respondents. There are learned counsel,
Number 2.
respondent number 2. Learned counsel for the respondent number 2 has submitted a APP attendance to the, huh? Learned counsel for the respondent number 2 has submitted that although by the last order dated 5/4/2022, this court had directed payment of 20% of the awarded amount before the trial court with a liberty to the complainant to withdraw the same on due identification, on the approach of the respondent number 2 before the trial court. The trial court has refused to pay the amount because on the ground that the records of deposit are not available, full stop.
No, not the deposit, Lordship, the whole.
The records of the case are not traceable, full stop. The learned counsel for the petitioner has produced before this court a receipt issued by the Court of the Judicial Magistrate First Class Kamrup Metro,
Where the case is
issued
pending.
on 7/4/2022 in connection with CR number 1169 of 2015
So that is the case.
that the court had received an amount of rupees 1,72,000 from one Pramod Sinha. Full stop. The learned counsel for the respondent number 2 is at liberty to obtain a certified copy of this order and produce the same before the learned court of the CJM to facilitate tracing of the file and release of the amount due. Release of the above said amount, full stop. The learned, records from the learned trial court also has not been received.
Not received.
Hmm?
Have not been received.
Records have not been received by this court as called for by the order dated 542022, full stop. Registry to issue reminder and registry to issue reminder again, full stop. Let this matter be listed again on the 28th of January 2026. 28th of January, Glu. 28 January. Oh. Can give this back. You can give it very detailed.
6.
Much always.
Deeply applied.
Wait, please, your lordship.
Hmm.
Lordship, this is revision against the concurrent finding under 138 of the NI Act.
Hmm.
Dictated by the trial court as well as the appellate court.
Hmm.
Lordship, there is a revision, there is a IA along with the revision.
Hmm.
In IA, there is no effective order passed, but the relief that has been sought in the IA has already been decided in the revision petition.
What is it?
We prayed for suspension of the sentence and allowing the petitioner to remain on previous bail.
Hmm.
That order is part of the revision petition.
What is that IA number? This is item 6.
Item number 13.
Item number 6.
Item number 6, lordship.
IA criminal number 13 of 2024 में लिखिए. By the order passed on 9/1/2024, the petitioner has been allowed to remain on previous bail in connection with CR within bracket NI case number 42 of 2018, which was granted by the learned ACGM, Lakhimpur, not Lakhimpur, full stop. In such view of the matter, the learned counsel for the petitioner submits that no further orders are called for in the interlocutory application, full stop. Accordingly, the interlocutory application stands closed.
Let me submit, Lordship.
Hmm.
This revision petition is per se not maintainable.
Very good.
Then the IA could not have been filed there.
Very good.
Seeking the concurrence.
Learned counsel for the appearing for the respondent number 2 has submitted that the IA criminal petition is not maintainable. A sole respondent is not maintainable. इसको ऊपर लिखिएगा, हाँ? Counsel for the petitioner जब बोला है तब लिखिएगा. Yes.
And your Lordship, the very fact that revision has been filed, revision could have been filed in a very few grounds.
Are we taking up the revision for disposal
For
today?
admission.
So this is for admission.
Admission.
Okay.
If your Lordship permits, then.
Yes, are you ready?
So I'm ready for conduct the hearing. Regarding revision, there's limited points that I need to place before the lordship.
Hmm.
The first point is the contention of the complainant, that is the sole respondent before this court, is that on 19/6/2016, the accused person approached her for a financial assistance of 9 lakhs that has to be repaid on the 26th. Means 9 lakhs is to be given for today, which I shall repay on the very next day. Then there comes what is the source of her income? What is the mode in manner in which the amount has been paid to the accused persons? There's nothing, not a single whisper in the complaint. The entire thing has been placed on record at the time of consummation of the complaint as PW1. For a single day, one person has given a loan of rupees 9 lakhs. That too, there's no source of income. That amount has been claimed to be paid in cash. That lady is running a shop of clothes wherein she sells the
Was the
clothes.
check issued by you?
The check has been issued by me. I have taken a plea before, the consistent plea from the replying of the demand notice as well as in my SD, that I had taken a loan of 50,000 from the complainant. Against that, I have issued a security check. The same said check has been misused by the petitioner, by the complainant. Lordship, there is one more thing. Section 114G of the Evidence Act will be attracted in this case, Lordship, because the complainant, while she was examined as PW1, she admitted that there was one agreement executed between the complainant and the accused person at the time of lending the amount of rupees 9 lakhs. That agreement was not placed as part of the case record.
You did not also call for it.
That agreement is in the hands of the complainant.
I think there's something in the evidence which which allows you the opportunity to call for documents from the hands of the,
Lordship, if the trial court record is before the Lordship,
uh,
that there's a suggestions whether you can place the documents on records, he said no. As the TCR is not on record, this is a fit case where the revision should
Concurrent
be
findings of the court, Your Honor. Concurrent findings, page 55 may be read.
but no, the TCR is not here. TCR is not here, full stop. Acha, you write down, that IA criminal we have to dispose of because there is an order in the main petition saying that she is allowed to remain on previous bail. So
File
keeping the
appropriate-
IA criminal is of no use. You have to get this order modified if you want to. So by the order dated 9/1/2024, comma, the this court has allowed the petitioner to remain on previous bail and steps for service of notice upon the respondent was required to be taken. Full stop. Accordingly, the respondent, the sole respondent has appeared through Mr. KK, through Mr.
AM.
A.M. Mohanto. Full stop. Admit it, call for the TCR and have it heard on immediately on receipt of the TCR. Huh? Admit the revision. Full stop. Call for the TCR. List again on. This will come from where? Not looking for. 29th of January,
Yes.
2026.
I oblige.
In 7 to 12.
7 to 12.
Please, Your
Transfer
Lordship.
petition, yes.
Kindly pass about a matter for time being, Your Lordship.
They are, all the matters, they are getting same, my lord. This and
Hmm.
that way always, they're taking them, my lord.
What is the interim order passed?
All cases, they are the interim order, my lord. There's a NIA case, my lord. We
Ah.
want to transfer the case from Odalguri to somewhere, my lord.
You have objections to that?
We have objection, my lord. There is no bona fide reason that not got my lord fair telling or Odalguri. They have filed a, my lord, FIR before the Odalguri police station, my lord. Somebody has been obstructed while coming to the Odalguri.
Hmm.
That cannot be a ground, my lord, for transferring the case. And the all the my lord cases are pending before the Odalguri, my lord.
He wants a passover for the time being or for the day?
Time being.
For the time being, sir.
I'm being, my lord.
Accommodate her for some
My
time.
lord,
Please, Your Lordship.
For time being, huh? Yes.
In this case, my lord,
Hmm.
one, my lord, complaint case has been filed by the respondent, my lord, in Kamrup rural at Amingao, my lord.
Hmm.
So kindly have a look at page, my lord. I have filed this petition for transfer of the proceeding from Kamrup Amingao to
Hmm.
Borbeta, my lord.
Hmm.
As the entire jurisdiction, my lord, entire cause of action, my lord, arose in the district of Borpeta, my lord. Kindly have a look at page
You are
Nine
the,
onwards.
you are the,
accused, my lord, in complaint case. Accused in complaint case, my lord.
hmm.
And I have filed this petition for transfer of proceeding, my lord,
Why?
from, my lord, they are, my lord, as because the, my lord, accused person himself belongs to, my lord, Borpeta.
Hmm.
And the entire cause of action, my lord, of the incident, my lord, arose in the district of Borpeta, my lord.
Then why is he saying that he is,
But
from
merely, my lord, some
not-
projected witnesses are, my lord, enlisted in the complaint case.
no, in the
As-
complaint itself, the complainant is from North Guwahati.
Yes, so complainant from North Guwahati, my lord.
Ah,
But, my lord, cause of action, kindly have a look at page, my lord. The complaint case, my lord, page 9 onwards, my lord, and the relevant portion, my lord, at page, my lord, 7, my lord, page 7. That is the, my lord, basic cause of action, my lord. Page 12, my lord, paragraph 7, page 12.
There are 7, my lord. May I read, my lord?
Hmm.
That the complainant begs to state that therefore on 8/1/2023, the complainant along with her husband and another 2 persons approached to the accused in its head office situated at Borpeta.
Hmm.
But the owner of the accused company
We'll have it after some time. There's no one for the respondents, although Wakalatnama had been filed.
uh,
Huh? You cannot allow it or dismiss
My
it.
lord.
Nah. Have
Sir,
their
we-
names been shown? You are at item number 13.
Yes, my lord. Their name, all, there are so many advocates, my lord.
Hmm.
Not only one, my lord, so many advocates
Hmm.
is there. Sir, yes.
এটা স্কুল দি দিব for respondent in item 13 code number ইমান বুলি
After some time, or my lord,
after some time after
obliged, I'm waiting.
Item 14.
Obliged, my lord.
yes
Your Lordship, may I request for the over of the matter for a timely until my senior counsel arrives.
so for the time being yes wait for some time being Someone I think I might be free. Hmm.
Lordship, trial court record has
Hmm.
been received, my lord.
Advocate will do why advocate respondent counsel for the respondents will in item 13
Trial court record has been received, my lord.
trial court record has been received I say
Hello.
My lord, it states against respondent number 2 has been, my lord, already. my-
He's here, yes. So what do we do?
Lordship, you can fix it for the for IL Lordship. Admit
I,
it,
what is the I for?
Lordship may admit it, Lordship, and thereafter.
I for what?
I for bail, my lord. He is behind the bar.
Since when?
Since, my lord, from the date of judgment on 6/6/2025, it's around 7 months, my lord. And earlier.
During the trial, you were on bail?
Yes, no, my lord. Oh, yes, my lord, bail. And before he was arrested and put behind for around 5 months.
5 months and then he got bail and thereafter from the date of. Where is the judgment?
Judgment is at page, my lord, 21 onwards.
A cursory look, just a cursory look. We are not disposed to say.
27 is the, my lord, first page. Again. Date of judgment is on 6/6/2025 and date of sentencing on 17/6/2025.
Where is your 313 statement? Have you annexed it?
No, my lord.
No.
313, I have not annexed.
They received lordship.
Hmm. Hmm. Okay, trial court records have been received. When can we have it?
Morning. Be admitted.
We'll have it on the 22nd. Hmm? Or 20th. 20. Oh. Hmm?
What a respondent.
You appeared in October, now you are filing our objections, then he'll say that we'll need to file our dissent. You appeared in October, you could have filed it. Entire month of November gone. Huh? The trial court records as called for have been received. The respondent number 2 has also entered appearance. Stop and seek some time to file their objections. List this matter again on 20. Admit. List this matter again on 20th of January 2026 for consideration.
Appeal admitted and for
So
consideration of IA or lordship may kindly fix it on another date. Appeal may be admitted because it is statutory appeal.
So we have admitted the appeal. We are not saying about the
IA
you see,
lordship.
IA. We are just going to take it up on, since the records are here. He is here. We'll hear the matter. We'll go this way or that way. One day we will decide the petition. Then we'll again decide the whole appeal. Why? We'll admit. We have admitted it. We'll hear the whole thing on 20th of January 2026. Since the matter, since the entire matter is proposed to be heard on 20th of January, no orders are called for today on the interlocutory application. Yes. Yes, sir.
May I please? Lordship, in this case, appellant was convicted by the Larned Trial Court. He premised that he has pleaded guilty, but that is he denied. Lordship, kindly have a look at the impinged order that started at page 57 of Annexure 4 and binding of the Larned Court at page 59. Lordship, kindly come to page 59.
Pleaded guilty.
Lordship, then your Lordship kindly come to a statement of the accused that was recorded by the Larned Court. Page 55, Lordship, Annexure 3.
Page 55.
Lordship, Annexure 3. No question put to him. So question was put by the learned trial court, 3 question, Lordship. And in the question number 3, he clearly stated.
Search is true. Yes, where is the plea of guilt?
Lordship.
Where is the plea of guilt?
And the Lordship, even if he pleaded guilty in that case, also in such a serious case, court should complete the trial. There is a judgment of our court, Lordship.
Not only
and
obtained a trial, he has to be explained that this is being taken as a guilt and
Para 7, Lordship may look 8, Lordship 10, 9, 10. Para 21, Lordship.
And this is what I was saying. The plea of the accused must be, there must therefore be clear, unambiguous, unequivocal, and the court must be satisfied that the accused has understood the nature of the allegations made against him and admits them accordingly.
In this case, it is totally lack, Lordship. And para 21, Lordship, this Honorable High Court clearly stated that court must ensure that he is pleaded guilty voluntarily. But in our
He has admitted that he has allowed someone to keep a bag without asking what is the content of the bag.
Lordship,
Does it amount to admitting the fact that he was harboring NDPS? Any narcotics? Yes, what do you say?
Lordship, instruction not received.
When will you put behind bars?
Lordship is the date of the order, Lordship.
Huh? Date of which order?
This order, Lordship. Imprimed order, Lordship. It is on 25/7/2025.
Yes, sir. Can that be a plea of guilt? We just want some of your insight. Have page 55 for a moment. Please see. Is it an admittance of an offense under NDPS? Page 55. So-and-so officials conducted search in your house. It is true. During search, they recovered huge quantity of so-and-so tablets from your kitchen. One black bag was recovered from my kitchen, which was seized, and therefore I was taken to so-and-so, was opened in my presence and recovered tablet. Do you want to say anything about the case? One Habibur Rahman called me one day before the occurrence, told me he has kept the bag in my house and I allowed him to keep the bag. He was known to me as we used to work together. He resides at Imphal. I have committed a mistake. I am a poor person. I may be excused. I have this much to say. Where is the admittance that I know that it contains such and such things?
He may not admit it, Lordship, but Lordship, when that substance is found in his house,
Therefore, that has to be proved that it was found in his house, conscious possession. He knew what it contained. Habibur told him or did not. These things will get proof. Could it be, could the conviction come on a plea of guilty in this manner is what we are asking you. The only ground for conviction is he has pleaded guilty.
That is not there.
Huh? That I don't think this is a plea of guilt. And he has not been explained. Look, sir, if you say this, that means the bag was yours. You are in conscious possession. That it means that you know what was in there. Are you pleading all that? Has it not to be told to him? If you want to read this last paragraph as a plea of guilt, then he has to be told that this means you are admitting that you knew about the tablets.
One more question was required, Lordship.
That is not there. So not on the plea of guilt. It can go for a full trial. No difficulty. But on a plea of guilt, this order has to go. Instructions or not, this order has to go. When will you have your instructions? 2-3 days time.
Was required for giving
Okay, so-
condition.
So this order of conviction has to go with liberty to the remanding the matter back to whether proceed in a full trial or not. They will decide. We'll remand it back.
That
Were you on bail?
No, but at present he is in custody and
Were you on bail during the trial?
yes, yes.
He
I
was
was-
on bail. So being set aside, release on liberty. Or we'll set it aside, ask him to file an application before the learned trial court, keeping in mind that he was on bail during the trial. During that trial, he'll move a proper application. He may be allowed to go on bail with whatever conditions the trial court wants. Tell us.
Lordship, once your lordship interfered with the order, any further detention is illegal, lordship.
Hmm?
Any further detention is illegal once your lordship interfered with the impeached order. Any further detention is illegal as he, during the period of trial he was in bail, lordship.
What was the amount recovered?
Lordship,
You are saying huge quantity. What is the huge quantity?
lordship
Commercial quantity.
page 18, page 18.
Commercial quantity.
Lordship,
Then-
commercial quantity.
Then first suppose there, we'll give you the liberty.
Lordship,
We'll set aside the conviction. You approach the,
trial court.
we'll give the liberty to the trial court to proceed with the trial.
Lordship,
During trial, you make an application there.
lordship. Lordship,
And we'll record that you were on bail
lordship, lordship,
on the earlier round of trial.
lordship.
Heard Mr. So-and-so learner counsel appearing for the petitioner, also heard Miss So-and-so learner counsel appearing for the DRI. Huh? For the customs. DRI. At the outset, the learned counsel for the DRI has submitted that, yes? No. Has submitted that instructions are still awaited in the matter and she would require 2-3 days time. Full stop. Or she would require some time. Full stop. The learned counsel for the petitioner has drawn our attention to the statements recorded at the statements recorded under section 313 of the CRPC, to assert that the answers given by the petitioner of the questions put by the court cannot be constituted as a plea of guilty in a serious offense like that of under the NDPS Act, full stop. He has drawn our attention to the impugned judgment dated
25/7.
25/7/2025 and has submitted that the only reason for convicting the petitioner was his plea of guilty. The learned counsel for the petitioner has placed reliance on the judgment delivered by this court in state of Mizoram versus Rameng Maiwa. Take it from here. Reported in 2006 1 GLR 745, to impress that the aforesaid answers given during the examination under section 313 of the CRPC can in no manner be termed to be a plea of guilt, full stop. He has further submitted that the petitioner was never explained the consequences which may follow on his admitting that he had allowed one of his friends to keep a bag in his house from which the said contraband was recovered, full stop. The learned counsel for the petitioner has submitted that the only extent to which the petitioner had admitted the facts was that he had allowed one of his friends to keep a bag at his residence, and that from the said bag, the contraband was recovered, full stop. The counsel for the petitioner has further submitted that this cannot be constituted to be an admittance of the fact that the petitioner knew about the contents of the bag and that he had been in conscious possession of a contraband, full stop. He submits that he was not given any opportunity to defend and to put up a defense regarding the absence of conscious possession of the contraband, full stop. This court has gone through the order dated 25/7/2025 and this statement recorded under section 313 of the CRPC on the same day itself, full stop. Having gone through the aforesaid documents, this court is of the view that the statements as recorded do not inspire the confidence that the petitioner had pleaded guilty to offenses under what section 22C of the NDPS Act, full stop. In that view of the matter, comma, and since no arguments contesting the same have been placed by the counsel appearing for the DRI, comma, this court sets aside the finding of guilt of the petitioner in the manner done by the order dated 25/7/2025, comma, based only on the plea of guilt, full stop. Accordingly, the conviction and the sentences imposed by the order dated 25/7/2025 and the order dated 37/2025 are set aside, full stop. The matter is remanded back to the learned trial court to already the charges are framed.
Charges framework.
Therefore 313 statement to take up the trial again from the stage after the recording of the 313 statement of the petitioner hearing. 313 will be at the end of the day, to take up the stage after the framing of the charges, full stop. It is provided that the petitioner shall approach the learned trial court with the application praying for bail within a period of 7 days from today, along with a certified copy of this order, full stop. The learned trial court shall consider the same on the basis of merits and on the requirement of imposing such conditions as may be required to ensure his presence during the trial, full stop. It has been submitted by the learned counsel for the petitioner. Ye sentence aage aayega, huh? It has been submitted. Ye wala sentence aage aayega. It has been submitted by the learned counsel for the petitioner that the petitioner was on bail. He was on bail.
Earlier, Lordship, during the trial, Lordship, he was on bail.
No. What trial? Was earlier on bail and he had not misused the said bail. In said view of the matter, the petitioner will be at liberty to approach the learned trial court. Wo wala sentence liyega, huh? For bail will be considered on its own merits by imposing such conditions, full stop. Criminal appeal accordingly disposed of. Anything else? No. Make some submissions, read it.
Online. Finding item 14.
It will dispose of. Yes.
Lordship can dispose of this matter also because this
main-
also requires a remand, Lordship, because there is.
Main issue is covered.
Huh?
Main issue here is covered.
What is the main issue?
This the order.
Affidavit.
Yes, affidavit.
Filed affidavit.
Rajneesh versus Neha, both.
Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr. So-and-so learned counsel appearing for the respondent number,
I am appearing for both the respondents.
for both the respondents, full stop. The learned counsels for both the parties have submitted that this matter would require a remand back to the trial court, since the law laid down in the case of Neha versus Rajneesh.
Rajneesh versus Neha.
Huh?
Rajneesh versus Neha,
Rajneesh versus Neha.
2021 2 SCC.
Likilo. Had not been followed in as much as neither of the parties had filed their affidavits,
On assets and liabilities.
affidavits on assets before the learned trial court,
Assets and liabilities.
assets and liabilities before the trial court, and before the learned trial court had come to a conclusion regarding the quantum of maintenance required to be paid. Full stop. In view of the consensus arrived at by the learned counsel for the parties, full stop. This criminal petition is allowed. Is allowed by setting aside the order dated,
Order dated
by setting aside the,
1/2/2025.
huh?
01/02/2025.
You are not aggrieved by the giving of the, by the liability of maintenance, only on the amount of it.
Yes, amount.
1/2/2025, by which the quantum of maintenance had been fixed. Full stop. The learned trial court shall now require both the parties to file the respective affidavits of assets and liabilities, and thereafter quantify the amount of maintenance to be paid in accordance with law. Full stop. Accordingly, this criminal division petition is allowed in the above terms. Full stop. LCR আহিছিল নেকি একবার? Full stop. The learned counsels are at liberty to approach the trial court with a certified copy of this order.
Parties are at
Or the parties are at liberty to approach the learned trial court with a certified copy of this order to initiate further proceedings. Criminal division petition disposed of.
Much obliged.
I will give my name.
Well,
Great.
Yes, sir.
Sorry, 6 numbers of petitions are filed by the petitioner. Now, in item 7, Lordship, in other items, my learned friend Manasarani has appeared, and one item lost score, Mr. Losko. But item 7 is unrepresented. We have taken steps, but nobody has appeared.
Show us why it should be transferred.
Lordship, what happened, Lordship, the petitioner before your Lordship is the aged person. Now, 6 numbers of cases were filed against the petitioner. 3 different complainants. Now, your Lordship will find in item number 7, page 20, Lordship, annexure 3. Because
page 20,
annexure 3. Here in this case, what happened? The petitioner was allotted with some government work. After execution, a portion of the work, because of his poor health and financial constraint, he could not complete the work. Now he took assistance of these 3 complainants. Now during the trial, some threats were given to him to make the payment. Or
you are for the
I'm from
complainant.
Maldon.
You are the complainant.
I'm accused.
You are the accused.
Accused.
And the complainant has threatened you.
Yes.
Very well. Yes.
This is the item, page 20 is the FIR laws before the police station. Similarly, on your honorable Lordship will find on the 1912 also it's mentioned in the that FIR itself, and 1912-23 also the same similar
threat was given to him. The time and again he was subjected to threatening. Now, here in this case, my defense, the petitioner as an accused, his defense is that without executing the work, they have presented the check for payment. Now, I want to examine the government personnel from government department. So they are not interested to attend the court at Udalguri because of this third person, sir. Now, I want the case to be
If your witnesses are not coming on appropriate prayers made before the trial court, will it not make arrangements?
If that is done, so no problem. Yes,
Or
partner.
we can direct the police to. Have you find out what has happened to your FIR that you had lodged? Any
GD entry was
petition
made.
filed before the concerned trial court?
Only GD entry was made. No FIR was
There
made.
is a certain procedure where you can find out the status of the case.
Lordship,
Huh?
but I have filed an affidavit also in this case that I was most probably additional affidavit was filed because Honorable Court was.
No, we cannot keep the case hanging, sir. It has to be decided.
If
If you are in threat and if you have filed an FIR, you have to tell us what you have done after filing of that FIR. Did you ask for a status report before the
No.
magistrate's court?
Lordship,
Now, if you had asked for a status report, the magistrate would have come to know about the situation. Then provisions could have been made for witnesses to appear.
we have filed an affidavit, Lordship. We have
Saying what?
stated in this case itself.
What have you said?
Para 4, Lordship.
Huh?
That the petitioner state that as many as 5 other cases against the petitioner are pending before the learned Chief Judicial Magistrate. Let me start with para 3. That the case was listed before the Honorable Court on Imam as motion as Honorable after hearing the counsel for the petitioner as well as Public Prosecutor Assam was pleased to issue notice to the respondent returnable amount. The Honorable Court also directed the counsel of the petitioner to take necessary instruction as to whether any case has been registered upon the FIR lodged by the petitioner with officer in charge Udalguri PS number on so. Next paragraph, that the petitioner state that as many as 5 other cases against the petitioner are pending before the learned Chief Judicial Magistrate Udalguri. And while petitioner appearing in 4 cases, including present case anarchist number so, the petitioner was threatened by some unknown person with dire consequences in the DC campus Udalguri 19/12/23. Which cast a serious apprehension on his life and in view of the such threatening, the petitioner had lodged an FIR before the officer in charge Udalguri Police Station on Iman. Thereafter, the petitioner had inquired about the status of the FIR and came to know that the police Udalguri PS made a GD entry so in pursuant to the said FIR dated Iman, and the petitioner was given understanding that the case has been investigated by the police. That is the update.
Mr. Parashar, there is a certain GD entry. A issue is that the accused was threatened when he went to defend himself in the court. An FIR was lodged. There is a GD entry number. That was in the year 2023. Given a copy of this affidavit, would it be possible for you to find out if we can facilitate the case at the place where it has been instituted? Nothing better than that. Whenever he needs to come, he'll have an application filed before you. Escort him to the court and escort him back.
Earlier GD entry. After that, yes.
They will arrange for him to appear at in the court, and we will have the expenses paid by him.
Before that, this cases.
That is what we were asking, whether it is possible for you to have your instructions, whether this GD entry has culminated in anything. If some threat has been perceived, we would request the concerned police station to afford him security as in when he requires it. Only for the purposes of attending the court where he will put up the summons because now he's under NBW. Is it not?
No, matter has been, all the matters has been
No,
stayed.
you are under NBW. NBW has been issued against him. So if he takes your assistance, you can also assist the court by ensuring that he is put in a place where
You're right.
it will not be difficult for him to attend the proceedings. Huh? NBW stayed or not? No.
No, no. But all the matters has been stayed, most probably, and you.
No, this additional affidavit has come after the stay order.
Just plea, my lord.
Huh?
Just taking a plea, my lord. To get
Yes,
the
now we'll have this in January. On,
My lord,
you will take this up for disposal, sir. In January. January, we'll have this for disposal. Will it be possible, Mr. Parashar? Yes?
hearing for respondent number, my lord, 2, in item number 8, 9, and 10, man. I have filed my affidavit in opposition.
I'm 11, 12, my lord, item number.
Any objection in what the court proposes to do?
My lord, there is nothing, my lord, only to, my lord, get transferred, their file, close the complaint, my lord, nothing
No.
much.
We are not going for all that. If a man has made an FIR, he has apprehended some action
There is nothing, my
without
lord, how we
without
will
putting
proceed.
anything on your clients.
My lord.
The police tells us the extent of the apprehension. If required, he would make a petty application.
My lord,
Police would ensure he reaches the court safely and he goes out of the district safely,
provide security.
if
my lord.
required at his expense. What is the
Yes,
difference?
My lord.
Your lordship,
Huh?
it will be too expensive. because
Who
I have
pays
to
who
bring the
pays for the
witnesses
diesel?
also.
Who pays for the food?
Look, they are enjoying the stay, my lord, they are
Uh,
supposed
we-
to get
they-
crores of rupees.
From
This is not proper
2020,
submission. We are not entering stay.
from 2024, 1 month more. 1 month more.
My lord.
Nobody has appeared for respondent number 2, although someone, notice has been issued.
It is your
So,
case.
amicus-
It is your case. No amicus. We'll
No,
just
not-
find out if you are under threat or not and we'll let the matter. proceed.
Not-
Heard Mr. Swenson and a counsel appearing for the petitioners in all the cases. Full stop. Mr. Sarania appears for the
Item number 11 and
11
12.
and 12.
respondents in respondent number
11 and 12.
2.
for the respondent number 2 in item number 11 and 12.
Sure.
Mr. Swenson.
Number
8, 9, 10.
For 8, 9, and 10, man.
8, 9, and 10. None appears for the respondents in respondent number 2 in item number 7. Full stop. The grievance raised in this transfer petition is no, don't say grievance. The prayer made in this petitions is that the petitioner apprehends a threat to his person and life at the hands of the respondent number 2 in each of the cases when he proposes to participate in the trial initiated at the complaint of the respondent number 2 in each of the petitions
My lord, in my case,
under
my
the
lord,
negotiable instruments act.
respondent, my lord, there is no other respondent. All respondent.
Respondent number 2 oblique sole respondent koi thodi ba, huh? It is the case of the petitioner that he had filed FIRs alleging threats by the complainants in the Negotiable Instruments Act cases. Cases filed under the Negotiable Instruments Act against the petitioner. Full stop. He has also filed an additional affidavit bringing on record the statement that the FIRs lodged by him against the threats had culminated in GD entry number 15 dated 2012-2023 in the police with the police of Udalguri police station. Full stop. At the request of this court, Mr. K.K. Parashar, a learned APP, has submitted that he would be able to obtain the status of the investigation, if any, held with regard to the aforesaid GD entries and the FIRs lodged by the petitioner, full stop. The counsel for the petitioner has undertaken to serve a copy of the transfer petition and the affidavit filed by the petitioner to Mr. K.K. Parashar for his doing the needful, full stop. List this matter again on 20th of January 2026, on which date Mr. Parashar shall make an attempt to inform this court, make an attempt to inform this court the status of the investigation carried out with regard to the GD entry as stated by the petitioner, full stop. Further orders should be passed upon receipt of the status of the investigation, full stop. An attempt would be made to dispose of the transfer petitions on the next date of listing, full stop. Interim orders to continue till then.
David. Yes.
Yes, sir.
Sorry, I'm preparing for the respondent. I'm paying for some time, my lord. We will file objection, my lord. Immediately after vacation, my lord.
My lord, in this case, my lord, there is no any stay, my lord. That's why I am for the till, my lord, till disposal, my lord.
Why do you want to transfer?
My lord, kindly have a look at page, my lord, at their complaint petition, my lord. The prima facie, my lord, it is very much
The
clear, my lord.
the jurisdiction.
Jurisdiction, my lord.
Jurisdiction. Okay. So now what do you say on the stay?
Immediately after vacation, my lord. Any date, my lord.
What is the next date fixed in the matter?
There is 9/1, my lord.
9/1 then?
5/6, my lord.
Huh?
5 on 5 or 6. my
On
lord.
5. On 5th?
Obvious.
It Mr. So-and-so and counsel appearing for the respondent number 2.
Sole respondent.
For the sole respondent in the matter has submitted that he may be afforded some time to file his objections to this transfer petition, full stop. Learned counsel for the petitioner has submitted that the matter is proceeding in the trial court, and since the issue of jurisdiction has been raised, he has prayed that the proceedings in before the learned trial court may be stayed, full stop. Considering the fact that the next date before the learned trial court is fixed on 9/1/2026 as stated by the counsel for the respondent, list this matter again on the 5th of January 5th of January will be immediately on the opening. On the 7th of January 2026, by which date the respondent shall ensure filing of their objections, if any, full stop. The prayer for interim stay of the proceedings in the trial court would also be taken up on the 7th of January 2026.
Much of this.
Please, your lordship.
Yes, sir.
This is for your lordship, custody of certain goods, your lordship. Your lordship may kindly peruse the earlier order, your lordship. Your lordship, they are directed to take, in fact, instruction, your lordship, as to whether they have received any report from the forensic, your lordship. Para 4.
Why were they seized?
Lordship, these
In
were
connection
seized
with
in
what?
connection with your lordship, those trading cases, your lordship. The allegation against not against the petitioner, your lordship. He was neither the named accused, he was not arrested, your lordship, nor surseated, your lordship. And the goods, materials which they are keeping, your lordship, they have not shown it, your lordship, in the search sheet as the materials they will rely during the trial. In spite of that, these are.
Then from where were they seized?
From my custody, your lordship.
But you are not.
No, I am not. I am brother of one of the accused who is also preparing a custody petition at your lordship.
Taking this a bit too far.
Getting a scam during the
Could
course
be.
of investigation.
Could be if you have not made any ground that these material would be required during the. Yes, where is it?
they are actively involved in this case. They are working as a supervisor to, Sumi Bora is also involved.
Yes.
Through this camera and drone, they are doing the advertisement, they have prepared the brochures.
Yes.
And thereby taking the investment from the innocent people on the plea of giving a enhanced rate of interest. And during the course of investigation, this has been seized for sending it to the FSL.
Has it been sent to the FSL?
This much I have.
At 2 o'clock, tell us if it has been sent to FSL as of now.
To the FSL, some documents are required to be retrieved.
No,
but
you
the thing
show us that these are these IMA numbers and all these things. These material have been sent for FSL. If it is lying with the FSL, we may have to wait because we cannot bring it back from the FSL to give it back to him immediately. But if it is not with the FSL, as of 12 o'clock on 15/12/2026, then
Delhi, I will have to get the information. This investigation is done by Delhi.
get the list of the things sent for FSL. The difficulty is this, madam. We understand your requirement to put up a good resistance, but we would not have resistance on facts from a council.
Yes, Your see, to that effect, I can understand.
That's
So
why
we
last
have-
occasion order is your.
Therefore, now if you can tell us from this 3/10/2025 order that the procure the FSL report with the with regard to the said articles on the next date fixed. Do you have that report?
Report I don't have, but I have got one instruction that still the investigation is going on in other.
Show us that these
Investigation.
show us that
is
these
concluded.
these have been sent for FSL. Show us that piece of paper at 2 o'clock, man. It's a WhatsApp thing, nothing more. We'll take your word for it. The date on which these things were seized, the date on which they have been sent for FSL, and the date on which the FSL has received it. 3 things.
Already informed them with, because the last order is there to give the FSL report on, but
If the information is not forthcoming at 2 o'clock from the CBI, despite the fact that
I have to get
Indigo
this
is not
from them.
functioning, we may have they
This
may have
is-
to travel far.
Investigation is done from anti-corruption 3 from Delhi. If the persons are available right now, because they are always on investigation, then I will get the information.
Get
and I
it,
will
get
sort
it from some person in the office. Get it.
One day time may be given by tomorrow.
By
maybe
tomorrow,
after-
yes, sir. By tomorrow.
Tomorrow.
Mr. S. Bothakur, Learned Counsel, appears for the petitioner and has drawn attention of this court to the order dated 30/10/2025, by which the Learned Standing Counsel CBI was given the liberty to procure the FSL report with regard to the articles in issue today. Full stop. Ms. So-and-so, Learned Counsel, appearing for the CBI, has submitted that the report is she has instructions that the entire matter is under investigation. Full stop. This court does not appreciate the absence of the report called for by this order date by this court through order dated 30/10/2025. At the request of the Learned Counsel appearing for the CBI, this court fixes the matter tomorrow, that is on 16/12/2025, allowing one opportunity to the CBI to send in to make available the instructions as to the date on which the seized articles in issue in this case were seized from the were seized, the date on which the said articles were sent for FSL report, for FSL examination, and the date on which the said articles were received by the forensic laboratory on being sent by the CBI. Full stop. It is made clear that the order dated 30/10/2025 had required the report of the FSL, but as of today, it is not even clear whether the said articles had been sent for FSL report. Full stop. The matter be listed tomorrow at by which date the learned counsel for the CBI shall be provided with all the instructions failing which necessary orders may follow.
Acha.
Deeply. Next item also similar.
Same,
Same.
same. Both the items.
Dip-
In these two items, karke bhi this.
He did the order, at least I could have sent.
A
that
copy of
immediately.
this order be provided to Miss so-and-so learned standing counsel for the CBI for her needful within the course of the day itself. You'll have it at 2 o'clock. Under signatures of the court master certified on an again.
Deeply.
Yes. 18 did you 17, 18 দুইটা একে বুলি করে দেখুন है ना
Wait, please, your lordship.
Yes.
With regards to the Zimma of a vehicle, which was seized with regards to an NDPS case from the residence of the petitioner, and the petitioner thereafter he was enlarged on bail also. The car was in his garage, and then
Yes, I remember that.
indeed, your lordship. The report was called for from the police, your honor. Twice the
sir.
Zimma was rejected in the trial court, your lordship.
Yes, sir. Car was at his home.
After some time also.
After some time?
Indeed.
এইটো অৰ্ডাৰটো কোন সোনকালে মানে এটা বজাত উলিয়াই দিব এইটো প্ৰথম উলিয়াই দিব sometimes
May I
Yes,
please,
sir.
Lordship, on last occasion, Lordship was pleased to direct the learned people, Lordship, to bring the status of the status from the learned PS, Lordship, whether further the vehicle of the petition is further required or not during the trial, Lordship. Petitioner has preferred this petition for Zimma of his vehicle.
it's from August 2025 further investigation what happened the vehicle was carrying the goods
Sorry, Lordship.
why was the vehicle
Lordship, the vehicle was on given on rent. I am the owner of the vehicle. Lordship, vehicle was given on rent. During that rent, some person took the vehicle and some
Contraband was-
contraband items were recovered from the persons who was traveling in the said vehicle.
but not in the vehicle
That I am not sure.
was it hidden in the vehicle
Maybe, Lordship. The FIR, as per FIR, Lordship, there is hidden, Lordship, but I am not very sure. And the petitioner, Lordship, was not named, not named the
no
person in the.
we are not on the petitioner part of it
Well, there is a report from the
And
IO,
Search it has already been
vehicle is not required for further investigation.
so we can release it from here
Written report has been.
Mr. Solar Council paying for the petitioner. You are SN Krishna Trail. Also heard Mr. KK Parashar, learned counsel, learned APP appearing for the state full stop. The learned APP has submitted that as per report received by the received from the investigating officer.
Dated
The vehicle
9/12/25.
on 9/12/2025, the vehicle is not required for further investigation at this stage. Full stop. The learned counsel for the petitioner has submitted that the charge sheet has been submitted.
Lordship, Learned PP has submitted that. Lordship, I am not.
Charge sheet submitted, no,
Yes,
charge-
yes.
And the charge sheet has also been submitted, full stop.
Yes.
In the above view of the matter, this court does not find any impediment in releasing the vehicle involved in this case on Zimma to the petitioner who has stated that he is the
Registered owner.
registered
Page
owner.
23, Lordship.
That he is the registered owner, full stop. We will send him to make an application to the trial court,
Yes. Right.
observing that the vehicle has to be released on such conditions as the trial court may deem fit. That will do.
I am ready to give an undertaking as and when court requires, I will produce.
That
the-
you do before
Yes,
the,
yes,
you
sure.
move a petition to the trial court. Will observe that it will be released to you on such terms and conditions as the trial
Yes,
court
Lord.
finds fit.
Yes.
Yes. In view of the above, comma, the learned, the petitioner is directed to approach the learned trial court with an application for Zimma of the vehicle, comma, which Zimma shall be given to, and the learned trial court shall award the Zimma of the vehicle to the petitioner on such terms and conditions as the learned trial court may deem fit in the facts and circumstances of the case. Criminal revision petition accordingly disposed of.
Deeply obliged, Lordship.
No.
Please, your lordship. Lordship, I have an instruction to withdraw a petition, lordship. As per
Why?
the party asks for the withdrawal.
Why? We must know. Bail petitions, we have told you the reason why we are not allowing a withdrawal on the verbal prayer. You have to tell us, otherwise we cannot.
The stated matter scan copy was called for and this is pending since 2024.
No, we just want to know why at this stage they want a withdrawal. Have they been released in by the trial court in the meantime?
That is not up to date, record is not.
That is what, and she is not making a statement. She has been asked not to make a statement. Can we find out?
We can, malab. That's I will verify. Will verify.
Today
After
itself
some
or
days.
some other? Yes, we'll take it up at 2.
22.
Similar pair for item
21, 22.
22, malab, here charges were framed under 6 of POXO and all this I have seen and notice 7 all this. But their evidence not there because long time back it this come malab. LCR has come long time back. Up to
No,
this record
she wants a withdrawal, is it not? She wants to withdraw it. Why is the issue?
Why is that?
If it is because, okay, chalo, itna din ho gaya, chodo, then it's a different issue. Something has happened
yes.
down below, we must know.
Like that case malab there.
We must know, na?
We'll check after some
Huh?
after some time.
I am 23.
The record show.
I think the prosecuting office there can help you on the updation. Yes, sir.
My lord, it's a charge sheeted case, my lord. If your lordship pleases to call for the, my lord, the TCR, my lord. It's, my lord, NDPS special case number 165 of 25, my lord. Pending before the additional district and session just, my lord, Nagaon.
There is a little snag. The case diary had been called for, though it is a charge sheeted case.
No. Earlier,
To be fair enough, my lord, the case was filed when the case was under investigation, my lord. Now the charge sheet has been laid, my lord. If your lordship pleases, my lord, the TCR may be.
The TCR has to come down. No?
Otherwise, malab, at the time, malab, it was not.
It was CD. No, that is why I said it is a snag.
Yes, my lord.
We can't wait for the CD.
Right.
Yes, heard Mr. So-and-so learned counsel appearing for the petition, also heard the learned APP. Full stop. This case was instituted at a time when the matter was under investigation and therefore by the earlier orders of this court, the case diary had been called for. Full stop. Today it has been submitted that the charge sheet has been submitted. Full stop. Accordingly, call for the scan copy of the TCR.
Of, can I say the number, my lord?
Yes, please.
NDPS case number 165 of 25, pending before additional district and session judge number 3, Nagaon.
So list again on, yes.
Registry will call, my lord.
An approximate time, when does it come? In the other cases, when does it usually come?
20,
20 January 2026.
I'm obliged.
Lordship, on behalf of Mr. S. C. Vicious, I'm paying for the time being. He is moving before court number 14, Lordship.
Lordship, TCR is also not available in the
Man is behind bars. You are not. TCR, okay. Let Mr. Biswas come. We shall hear him.
Wait, please, your Lordship. This is charge sheet matter, Lordship, on the last date, your Lordship has been directed, please to direct our learned PP to have written instructions.
Regarding?
This service of notice, Lordship, on the victim. This is a pocket charge sheet matter, Lordship.
Any updates?
Service instruction not received, my lord.
Huh?
Service instruction not received. It was sent from our office, but Morigaon instruction not
Lordship,
yet.
amicus may kindly be appointed because I have, this case has been filed on 11/11, Lordship.
My lord, amicus
So
may be
15/11
appointed
we will take
immediately
step.
after reopening, my lord. Amicus may be appointed immediately after reopening, may be fixed.
The service
According to
report-
my lord, notice has already been issued, Lordship, please. Otherwise,
issued.
I am behind the bar for
Yes,
last
it
6
is-
months,
it-
Lordship.
it is at the address of the FIR. Have you seen? Is the address correct? Huh?
It is there, Lordship.
Morigaon.
Is
It
it
is
the
to be
address
served to
given?
police.
Gomariguri.
So in the meantime, let the appears, their advocate will appear, otherwise amicus will submit, Lordship, because I am behind the bar for last 6 months, Lordship. And this bail petition is pending since 11/11, Lordship.
Otherwise, PW 1 and 2 examine victim and the informant implicated.
They are in the
What happened to the lady? Okay, she is recovered.
Recovered. PW 1 and 2 malat examine also. Malat.
Informant also examined the. They are
Okay,
in Lavabras, 6 F to hour.
the office note of 11/12/2025 reflects that the service report on respondent number 2 has not been received back by the section yet. Learned APP has submitted that there are no instructions to him that the respondent number 2 has been served, full stop. The learned counsel for the petitioner has submitted that the petitioner is behind bars since 19/6/2025. When?
19/6, Lordship.
19/6/2025, and this bill petition having been filed on 11/11/2025, comma, this court may consider appointing an amicus curiae to assist the court, and full stop. নামটো দিয়কচোন, কাগজখন নাই আপোনাৰ amicus curiae কোনোবা এজনৰ চিৰিয়েল নম্বৰ 4 থাকাজনক দি দিয়ক যোনে আছে হা লিষ্টখনত চাই দিব কোন আছে মোৰ মুখস্থ নাই Accordingly, so-and-so is appointed as the amicus curiae to assist this court. Srimati Bonita Chaudhary as the amicus curiae to assist the court. Full stop. Place this matter again on 20 when January.
Then Lordship 5. 5th of January, Lordship.
Immediately on the opening.
Lordship, because on 6, 7, 8, I will be Lordship.
9th will be back.
I will be out of station, Lordship.
5th.
TCR has already
On the
come.
5th, stop. The TCR is available. And a counsel for the petitioner is requested to submit to supply a copy of the supply a copy to the learned amicus curiae. Yes.
All right.
May I please also? The petitioner is behind bar for 81 days, my lord. Lordship, 14 is the FIR. 14, page 14 is the FIR, translated copy. The FIR is self-contradictory, my lord. May I read, my lord?
I'm reading it.
Lordship.
No, 154.
Yes, about the receipt, you are appointed as the makers. Yes.
Friday.
Yes. We'll bring it, no issues. What do you say?
Lordship, so far the allegation concerned matter, FIR filed on 23rd of September of this year, my lord. So far as the Lordship. There was a physical relationship prior to 8 months from the date of FIR, my lord. At FIR says, it was the month of January or February of this year, my lord. And after such physical relation with the petitioner, the victim got married after 3 months. And he gave birth to a baby thereafter. Then within 9 months, is it possible, my lord? Kindly come to the FIR
I did not understand. From
FIR
what we understood of the FIR was
filed on 23rd.
that the accused had some relationship with her.
Says that.
And thereafter she got married to one person, and then after 3 months a child was born. The husband said that in 3 months I cannot have a child, it is someone else's, and thrown out of the house. Now the lady says that it was that incident from which the baby is.
Lordship.
Yes.
Lordship.
What are you trying to tell us?
23rd September 2025.
February.
Prior to 8 months back, relation was taken place.
Yes.
Lordship. After 3 months of death, within 9 months, my lord, relation was also taken place and baby was also born.
You are saying that the incident happened 8 months ago.
8 months ago, prior
So
to
that was
January or February.
let us take February to your
February.
advantage.
Lordship.
February 25 incident. Then
Relationship, victim got married. And after 3 months, she gave birth a baby.
when did the victim get married?
He is not stated in the FIR, but so far my knowledge is goes, actually she was married to someone on April of 2024. And in the month of January, she gave birth a baby, and after 9 months of his giving birth of baby, the FIR was lost. So far as my instruction manual. In fact,
Do
today.
we have anything, sir? I'm a little bit. What is it?
My lord, yes, my lord.
What is the story actually?
Sorry, my lord, as per the statement of the girl, that prior to that, my lord, incident, yes, it was earlier, but at that point in time, she was minor. That is also when she is 183 statement is recorded, she is 18 years old, and there is a school certificate. Deobari Ami School. As per the school certificate, date of birth is 309/2009. So till
39 2009 September.
September 2009 to 2025 till 2000 date of FIR, she is 16 years.
She's still 16 years, so the husband is also in problem now. Yes. What have you done to the husband then?
One line may I put, my lord? One line, my lord. Victim herself is the informant. In the head note of the FIR, she stated, as per person, the age is 20. Instead of 21,
We are bound to take into account only the school certificate, nothing else. We are supposed to take into account only the school certificate.
School certificate is there, but in the 183, she stated her age is 18.
18. In the FIR, she says 20.
20.
from the ME school is as per admission register,
As per school register.
as per school register, yes.
Arrested on when? 26/9.
81 days, that is also a,
81 days behind bar, my lord.
Sir, see till now.
no, sir, sit till now. Only, Malat, as per as her statement, we stated that Vipul Sharma, yes, the accused has some shop and she has a debt of 900 rupees. Because of the debt, Malat, one day people forcefully took her and without her consent.
Allegations of, it lead to allegations of, even if she was a major, it's an allegation of rape.
That is there, that is there.
Minor consent does not matter. If she's a major, she has stated that she did not consent.
Yes, more Laura Boyok Atma, yes, yes. At the time of recording the statement 183.
That was in September.
183 recorded on.
Has to be.
September.
September.
25th of
Laura,
September. 20.
Laura Boyok Atma. So
Atma.
child is born on February 2025.
25,
And she says the incident is of
8 months back.
from
the date of
September. What is the Assamese version? Where is the Assamese version?
Your lordship, page number,
Page
page number 19.
Page number 19.
That is the person.
অৱস্থা বেয়া হোৱা ঘৰৰ পৰা মহোদয় মোৰ ঘৰৰ অৱস্থা বেয়া ভাতা এখন হাজিৰা ৰেচনৰ বাবে মোৰ ঘৰ
Yes, sir.
আজিৰ পৰা প্ৰায় 8 মাহৰ পূৰ্বে বস্তু লৈ 900 টকামান আৰু either the rent 8 months ago was 900 rupees, or she's saying that the incident occurred 8 months ago. Either of the cases, the child being born 8 months ago.
Yes.
It is not adding up.
Yes. That is.
Yes, what do you say, madam? Any
Contradictions.
Huh?
It will be contradictions.
Take down.
Run Malat.
8 months.
And the length, the length of detention, Malat. There is 81 days.
That is one part, and so cursory view does not feel that there is a consistent statement.
That is there.
Did not. Heard Ms. Swenson Learned Counsel appearing for the petitioner. Also heard Mr. Swenson Learned Counsel, Learned APP. Also heard Ms. Swenson Learned amicus query. Full stop. You are appearing for the respondent number 2, amicus.
Not amicus.
Oh, for the respondent number 2. Full stop. Who has filed her wakalatnama today? Please attach the wakalatnama along with the records of this case. In the absence of any official objections, full stop. The present case has been initiated from an FIR lodged on 23/9/2025, where the informant had alleged that about 8 months ago, the accused had taken advantage of her being a minor and had physical relationship with her. Full stop. The informant further suggested that she was married to one, she got married, and after 3 months of their marriage, she gave birth to a child. Full stop. After birth of the child, her husband had ousted her from his house. The counsel for the petitioner has submitted that the story projected in the FIR is not correct, since on later on statements, the informant oblique victim has made a reference that the child itself was born about 8 months ago. And in various statements made before various authorities, the informant has faltered in making a specific stand as to her age. Full stop. And APP, and she has therefore prayed that she has also submitted that the petitioner has been behind bars for the last 81 days as of today. Full stop. She has prayed petitioner be granted the privilege of bail at this stage, since it is apparent that even on the basis of the length of incarceration, at least full stop, the APP has submitted that as per records available with him, the petitioner, the informant is aged about 16 years as per the school register, whereas in different places she has in the 183 statement, she has mentioned her age to be 18 years, whereas in the FIR, she has mentioned her age to be 20 years. Where is the 20 years? Where do we find it?
Lordship, page number 16, in mid part, 6C, year of birth 2005.
Good stuff. The submissions made by the learner counsel for the contesting parties have been considered. Court has also considered the different statements made by the informant, and without expressing any opinion on the same, this court is of the opinion that the petitioner is entitled for the privilege of bail in the present case in the peculiar facts and circumstances. Full stop. Accordingly, it is directed that the petitioner shall be so and so, subject to the satisfaction of
Special Judge Poksho, Shivasagar.
Special Judge Poksho, Guwahati. Full stop.
Sibsagar.
Sibsagar. Full stop. Bail application disposed of.
Oblique.
I'm sorry, my lord, I was in other court, my lord.
Yes, sir.
My lord, this is a case of 483 application under NDPS Act. My lord, I was arrested on 6/4/24. That is, I have completed today, my lord, 643 days, my lord, behind the bar. No trial started, my lord. My lord, I am just placing our own High Court as well as the Supreme Court judgment, Ravi Prakash, first, my lord, where it has been said that Narcotic Drug Psychotropic Substance Act, Section 37 will not stand on the way in case the prolonged incarceration of conditional liberty will override the statutory embargo under 37. Prolonged incarceration is against the fundamental rights granted under Article 21, that is protection of life and personal liberty. That is the Ravi Prakash I am giving, my lord, kindly. That is the where it. Then, my lord, Asamuddin, our own High Court judgment. This is another case, my lord, where prolonged trial bail was granted, my lord. In a similar case of this Apex Court, my lord, I am giving another judgment of Apex Court, Nitish Adhikari.
Yes, madam, what do you say?
Lordship, thank you. Hi, Lordship.
What is the stage?
No, my lord, no charge was framed till today.
Charge sheet has been,
Charge sheet has been filed.
when was the this thing filed?
6/4/25.
Why charges not framed till now?
There is no material. They have to give so many, they are collecting. Still, they have filed the charge sheet within 180 days. That is the problem. Now they are waiting. They will file application to get those things.
Would the court keep on waiting if the charge sheet?
Court is not giving.
If the charge sheet,
court said no. There is a prayer. They have filed a petition before your lordship, not to grant bail. We have filed objection to that. That is also in the record. So, my lord, how long I will be behind the bar without trial? That is the only ground, my lord. Yes, my lord. My lord, truck was belongs to roadways, my lord. I was a hired driver on that day.
But it is said
Please
that
go
you are
on.
the owner also.
Yes, no, they have not arrested owner. Vehicle has been released on bail. Zimma.
Zimma. All those are here on records.
Yes,
To
yes.
whom has the vehicle been released? Where is the Zimma order?
That I have not given my lord here, but to my information, truck belongs to Joyram Roadways. Yes, that I have submitted objection. Joyram Roadways is the that is.
When did you file your objections?
They have filed the objection, my lord. And we have also given reply.
Eh?
Objection was filed on 20th of September. Page number 106, my lord. Then we have given a reply on
We have
8th
to
of
take it-
December.
No, we have to take a status of we'll take it up after some time. এইটো ষ্টেটাছটো চাওকচোন তেওঁলোকে বোলে অবজেকশ্যন ফাইল কৰিছে তেওঁলোকে বোলে ৰিপ্লাই ফাইল কৰিছে ইয়াততো একো নাই চাই দিওকচোন ৰিপ্লাইটো ফাইল হৈছে নেকি ন নেক্সট আইটেম yes madam kindly find out from the filing section whether it is under objection or something even your document is not here your reply is not here we'll take it up at 2 we'll take it up at 2 if it is there kindly move a slip to the court master we'll have it called for we'll look into it they have to be on record before us before we can pass an order either which ways like 8 of ready sir we'll take it up at 2 kindly have the
Sure. Judgment of approval में है.
if the objections are there if you can remove the objections give a slip to the court master he would call for the we'll have it yes
May it please your lordship. Lordship, in this case, lordship, can you peruse the last order, lordship? TCR was called for lordship. Item number 53. This petitioner in jail custody for 126 days, lordship. 53. Now, lordship, and regarding service, lordship, there is an instruction from this, there is a direction from this court to get the instruction, lordship, regarding service of notice. TCR, but the office notes say TCR received and the TCR didn't find the TCR there.
barring the length of detention what else is your ground it is not barring it is over and above the length of detention what is your ground
Lordship is an extramarital affairs, lordship, so for lordship, the only
with the
thing
minor
lordship minor as per FIR 16 years, lordship. But that too, lordship, FIR, lordship will find on page 14, lordship.
yes by when the TCR when should
Page
when
14,
should we-
lordship, is the FIR, lordship.
you move the petition when
Move, lordship, it's on first listed on 19/9, lordship. FIR, lordship, will find on vernacular that is on page 14, lordship.
Why is the case diary not coming?
Charge sheet and TCR. Charge sheeted case, Lord.
We'll have it immediately on the reopening. We'll await the TCR. The Leafoxton heard Mr. So-and-so learned counsel appearing for the petition, also heard the learned APP. The scanned copy of the TCR in connection with Jalukbari PS case number 343 of 2025 under section 64 of the BNSS, which had culminated in where is it? Where is it? Has not yet been received. Full stop. Registry to issue a reminder to special judge.
Here, the
Kamrup
forwarding
Metro.
lordship additional session judge come special judge POXO Kamrup Metro.
লিখি দিব হ্যাঁ forwarding of a apply. Page number?
Page number 18 lordship is a seen that forwarding report.
একদম উপৰত হা মই এনেকৈ circle কৰি দিছো. For the TCR from the page number, huh? Additional session judge, come special judge POXO.
Kamrup Metro, Guwahati.
List again on 6th. মোৰ এইটো ওলোৱা নাই 6th to চাই দিব. On the 6th of January.
Oblige.
Please, your lordship. Here in this case, lordship, I have paid for bail on the ground, two counts, lordship. First count is that, lordship, the quantity which was recovered from the petitioner is of intermediate quantity, lordship. It was clubbed together with another accused, lordship. Therefore, it is made commercial. And second ground is, lordship, that violation of section 47 and 48. And on last occasion, they took time to submit before this honorable court on whether 48 notice was served to the relatives or
yes.
Because in affidavit they said through it was informed through over telephone lordship to the brother, and then said lordship to father. So that is there. Lordship may dispose of my case because lordship what I am saying.
We can grant you time till 2:33. We are granting him the bail. You produce it, we'll consider it again, we'll keep the case pending. You can do that.
Because on similar ground, the other accused has been
So
granted.
you are not yet sure as to whether it was served on the father, the brother, the whom? To the brother, yes. And what efforts did he make? Did he do anything in the last 3 days? Huh? Therefore, when he sent that letter to the Bihar police station, the police station in Bihar,
He did not call the
definitely,
Bihar
then
police
he could
station.
contact within the day itself.
Just I am saying one.
Now it is becoming very difficult for him to contact.
Just few lines before lordship that. Just I am pointing out one thing. He is not calling the Bihar police. He is calling the relatives of the present petitioner now to get the signature. That is my difficulty, lordship. I have been informed that they were called. So if your lordship grants time, then I will be prejudiced, lordship.
Where
Because
is
the case is in
where is the IO from? This case is from where?
NCB, lordship. NCB, Union of.
No, the IO, where is he available?
His affidavit is there, lordship. Kamrup Metro.
Kamrup Metro. Give him a break from his busy life. He can come and perhaps. Kindly have the instruction. Also kindly have instructions whether he is calling up the relatives now to take signatures And in case he's doing that, he will be well advised perhaps to act according to your advice hereafter. And if at 2 or 3 you cannot tell us whether the father, the mother, the brother, whom did he try to contact, and if he has not been able to contact the Bihar police, violation of section 48, how long can we prolong his, how long can we say that yes, we are giving opportunities to the investigating authority? If the investigating authority is not cooperating with the proceedings in this court.
I have to say that they were. they
At
have
2.
com- How long?
May I please the Lordship? Last occasion, the Honorable Court was directed to take instruction whether charge sheet is filed or not.
Filed. Charge sheet submitted. When?
Petitioner is behind the bar 92 days.
When? 23/11/25. Should we call for the TCI and everything, or would you like to take a chance there? After the charge sheet. That is what I'm saying. He has filed this petition after the submission of the charge sheet. Yes, tell us what chance you want to take.
1.750 grams ganja was recovered. Petitioner is 58 years, my lord.
Yes, 1.78.
1.750 gram. ganja.
1.1.7.
750 kg, my lord. 1 kg, 1 kg point 6.
That is not
1
stock
kg,
for the
sorry.
week. That is not the stock for the week. That is the stock for the.
Honorable Court may kindly consider.
Tell us, the charge sheet has been submitted. You want to take a chance first there, which will be quicker, or you want us to wait? Call for the TCR scan copy. You'll take a chance there? Yes. But Mr. You are Mr.
M. Islam.
M. Islam, Learned Counsel appearing for the petitioner. The Learned APP has submitted that the charge sheet in the matter has been submitted on 23/11/2025. Learned Counsel for the petitioner had, though initially submitted that the quantity recovered is 1.750 kg, and this court may kg full stop, comma. He has submitted that he may be allowed to withdraw this petition to approach the Learned Trial Court. Stop. Prayer for withdrawal of this bail application is allowed. The petitioner is granted the liberty to approach the Learned Trial Court with a prayer for regular bail. Will stop the Learned on such approach being made. The Learned Trial Court shall consider the bail on its own merits without being influenced by the withdrawal of this present.
Number.
Yes. No? Bail application disposed on withdrawal.
Hearing item 30.
So,
Milord, I am on interim bail, but there is one problem, Milord. I have gone twice to record, give my statement. My statement has not been recorded.
I will note it down.
In fact, I have filed an additional affidavit also. Milord, first, I went on 3/9/2025, when after the interim bail, then thereafter on 23/9/25. My lord, my statement was not recorded.
Yes, sir. We are indicating we will record
Yes.
Mr. Chaudhary's submission, and in case you do not want to record statements, then why run after
Yes.
him? Then he can have his own freedom when you are not, when you don't want to record it. Or either record it. It has been submitted by the learned special public prosecutor, CM Vigilance Cell, that although the case diary had been received, comma, it has been connected with another case today before another bench, full stop. The learned Mr. Kane Chaudhary, learned senior counsel, assisted by Mr. T. Dewey, learned counsel appearing for the petitioner, has submitted that an additional affidavit has been filed in the matter, bringing on record the fact that although the petitioner had approached at least twice before the investigating officer of the case, comma, his statements have not yet been recorded, full stop. The learned special public prosecutor shall take note of the aforementioned statement and have his instructions on the next date fixed. List this matter again on
Team, any date convenient, Miller, after the reopening?
23rd of January, 2026, along with
Miller,
the
I'll
case diary.
still go again.
The petitioner shall be at liberty to approach the IO again to have his statement recorded. It is expected that the IO would cooperate. Full stop. Interim order passed earlier shall continue. List as directed before. Yes.
Please, Your Lordship. It is a 482 application, Your Lordship. And the thing is that, Your Lordship, on 10/9/2025, this honorable court granted interim protection to the accused petitioners. Accordingly, they appeared before the said concerned police station and cooperated with the investigation, Your Lordship. But, may I submit, Your Lordship?
Just a minute.
Bishallas.
This is something we are finding very interesting, Mr. Parashar. This time they are giving grounds of arrest and reasons of arrest separately. If you have page 19. This is good. Some formulation is there.
Yes, Lordship.
Yes, you were saying?
Yes, Lordship. I'm draw the attention of this honorable court at page number 22, Your Lordship.
22.
Yes, Lordship.
Yes.
There are 7 numbers of accused person, and on the date itself, one accused person, namely Konkon Pathak, he was arrested in connection with this case, and on the date itself, the honorable the learned trial court released him on bail, Your Lordship. And the relevant portion is at page number 22. If I read, Your Lordship, from paragraph number 2.
The interim is there. You are
Yes,
the interim protection. Let him have his updation about the recording of the statement on record. He has to have the records before we can dispose it. But Mr. So-and-so learned counsel appearing for the petitioner also heard Mr. K.K. Parashar learned APP full stop. By this court had directed the petitioner to approach the IO of Jalukbari PS case number so-and-so.
Up to date.
And it is stated by the learned counsel for the petitioner has appeared and statement has been recorded.
Yes.
Learned APP has sought for some time to verify the above statement. Full stop. List again on 20 January 2026. Full stop. Interim order passed earlier shall continue.
Much of it.
Your Lordship, kindly pass over the matter for time being.
Why?
My
Huh? On the last occasion, you have said, go through the CD which has been received. Huh? Otherwise, what is the allegation on? You are an interim.
Yes, your lordship.
Eh?
I'm on interim, your lordship.
Will fix it in the month of January or February 1st.
Yes, your lordship.
February 1st is an interim. You recorded your statement. Has the person gone and recorded his statement?
Yes, your lordship.
Before the IO, he has
Yes, your
gone. It has been submitted by the learned counsel for the paying for the petitioner that the statement of the petitioner has been recorded by the IO on the basis of the orders dated 11/9/2025 passed by this court. Full stop. The learned APP has submitted that the case diary is not available today, although there were orders to retain the case diary. He accordingly he accordingly prays for an accommodation to verify. Full stop. Mr. Biswas has submitted that the petitioner is on interim bail and the matter may be fixed immediately after the vacations. This the matter again on 2nd of February 2026. Interim orders passed earlier shall continue. Printing works.
Pardon?
He was doing printing works.
Oh, but these are all civil matters. Civil cases are also pending. There were 10 accused persons, all granted bail. Not even case diary was called for.
Yes. You wanted to say 21. Yes. Oh. When was this filed? 24. Heard Ms. So-and-so learned counsel appearing for the petitioner, learned APP appearing in the matter. Item 21, no? Learned APP has submitted that the trial has since culminated. Full stop. Learned counsel for the petitioner has submitted that they may be allowed to withdraw the present bail application. Full stop. In the facts and circumstances, this bail application is disposed of as withdrawn. Has not pressed, has not pressed. Yes, madam, we'll fix this up on Friday. Kindly tell us why he wants to withdraw. If there is a conviction, we'll allow it immediately. If there's some other reason, we'll allow it. But if it is another bail petition filed during the pendency of this petition, then we may have to.
Let's see.
On Friday, we'll have it on Friday, 22 to Friday detail. Short matter. Yes. Come back at 2.
Wait, please.
It is not required, no? I'll say that. But Mr. So-and-so learned counsel appearing for the petitioner. The request of this court, Mr. Local Learned Additional PP has taken telephonic instructions from the investigating officer or from the OC of so-and-so PS, who has stated that the charge sheet in the matter has been submitted and after some time, this has come. This is objection. Did you find out about your reply?
I have
heard Mr. A. Bhattacharya, learned counsel appearing for the petitioner. Also heard the learned APP who has produced before this court the report by the officer in charge, Hathigaon PS station, full stop. Report of the officer in charge of the Hathigaon PS station is to the effect that a written complaint had been received against the petitioner, which was entered as a GD entry via Hathigaon PS GDE number 31 of 2510-2025, and the officer in charge endorsed the same to the for investigation, full stop. During the investigation, the inquiry officer contacted the petitioner over phone and instructed him to report to the Hathigaon police station to verify the allegations. However, the petitioner switched off his mobile phone and did not appear before the authorities at the police station, nor communicated with the investigating officer, full stop. Thereafter, Hathigaon PS case number 44 of 2025 had been registered, in which charge sheet has already been submitted against the arrested accused person.
That was earlier, Lordship. I think they are mixing it up. There was earlier another case by the same informant. And this time when Hathigaon PS was calling, in that he was arrested, Lordship. And later on he was allowed to go on bail. Now the same informant, Lordship, he again following a Facebook report.
Which was already charge sheeted.
Yes, that is charge sheet.
Against the arrested accused person. The officer in charge has further reported that the petitioner had failed to cooperate during the inquiry proceedings, full stop. Mr. Bhattacharya, learned counsel appearing for the petitioner, has submitted that this report in all probability relates to an earlier incident where the accused applicant had been arrested and had been allowed to go on bail.
It has been charge sheeted, Lordship, the earlier one.
No, that is what he has said. Allowed to go on bail, full stop. Present report by the officer in charge, Hathigaon PS does not reflect that any further case has been registered against the petitioner, full stop. In fact, the report says that the inquiry remains incomplete and no case has yet been registered against the petitioner. No other case has been registered against the petitioner, full stop. That is what I've said. Therefore, it appears that no PS case has yet been registered on the present complaint referred to in
this petition,
in this anticipatory bail petition, full stop. The absence of any, then what kind of a bail we can grant him? No blanket bail.
It has to be
Only if a police case is registered. In view of the fact that no police case has yet been registered, full stop. Nothing further remains to be adjudicated upon in this anticipatory bail petition, full stop. The petitioner shall be at liberty to take appropriate steps in law in case other cases are registered against him. Bail petition accordingly closed. Anything else? That is what I said, that petitioner at liberty to take appropriate steps if any case is registered against him. Yes. Case diary was called for. Do we have it? Charge sheet is submitted, sir. Were you on interim? No.
No.
Without your participation, charge sheet had to be submitted. Would you like to go and appear there? The learned counsel for the petitioner is present. Full stop. Learned APP has submitted that the case has been charge sheeted. In view of the statements made, the learned counsel for the petitioner prays for the liberty to withdraw the present petition and approach the appropriate forum. Pray for regular bail. To pray for bail. Liberty granted. Anticipated bail petition closed. Yes.
Item 54. Here, I have your here.
To the we are granting the bail then.
Here. Deliver, there was informed by telephone. That is, his name is Mahesh.
There was that it suffices 48.
Approximately to see section 42.
Yes, suffices it.
Allegation, persons making direct inform about arrest. Okay, the police officer or other officer. The arrest person is other person is maybe disclosed. Also giving some information, also be designated police officer in the case. Yet two conditions are there. First is to inform his relative. That was done immediately.
What was the judgment? Informed writing.
Informing writing that is held
The
in
relative.
Bihan-
What is the judgment?
Bihan Kumar judgment lordship.
Bihan Kumar judgment it is. In section it is not there, but in Bihan Kumar judgment, Supreme Court has said that it has to be in writing. Approximate, see, that. Carries. The date of a copy here. Sorry. See, there is no. After. Was sent to his father. His name. Police.
Sending it to Bihar police, not trying to find out whether they have informed or not.
To them, but we have seen this, we have not received any complaint.
So we take it that it has not been served. Come back with a piece of document saying that it was served. We'll cancel the bill. We'll recall it. On a suspicion, can we allow violation of Article 22? That is the only question. To whom?
Of the petitioner.
Show us that the email to the police station is enough.
It is there.
That it is enough for 22-1. We can't go stage by stage, Mr. Akhil.
Says that,
Wait, show us.
yes, doctor.
Show us. The telephone communication is sufficient. Show us.
Supreme Court in October.
We do not find that people are using telephone nowadays.
Judgment of this honorable court.
Please.
Yes, doctor, I'm placing.
Hmm?
Is regarding substantial compliance, Lordship.
Paragraph 12 of the judgment.
Is of when? 12, okay. Why don't you read the second part of it? Scan copy was sent on our WhatsApp. Why don't you read the second part of it?
Yeah. That police note. Our case note.
Mr. We'll have to bind it down somewhere. We have a big playing field. We'll have to lay down the rules that we play within this. Papia was immediately intimated about the grounds of arrest of the accused appellant over phone, as well as the scanned copy of the notice under section 48 was immediately sent to her on the WhatsApp in her mobile number.
Here,
Ah,
here, the notice. That police note is available on the case record.
hmm.
The difference between the judge.
So when the factual parts are different, we'll have to keep this here.
But Lordship,
Scan copy on a WhatsApp is accepted by this honorable court.
both, because immediately it was sent, but
As well as
immediately it was sent through email. Also.
This lady talked with someone on the phone.
Yes.
Why was it not sent on the WhatsApp to that number?
Of the petitioner.
Why was it not sent to that particular number on the WhatsApp? Mr. Kier, what happens is when we are granting a bail because of some lapse on the part of the arresting authority, it does not reflect on the merit of the case in any manner, neither on the arguments made on it. What this court is required to do is evaluate whether it was correctly done or not. If incorrectly done, Mihir Rajesh Shah says, do it correctly. Have him in again, invite him back.
No,
Option is always there. But when there is a violation, there is a violation.
Commission, quickly, it was that police to his father.
Very. It is sent to Bihar Police.
It is up to your Lordship.
Perhaps our learned APPs would be witness to the fact that calling for a CD takes a long while. Therefore, sending it through the Bihar Police by an email. When 40th says 2 hours before, everything. When a phone call was made, the WhatsApp was there or not there, even if a statement that the WhatsApp was not there, so we could not. We are ready to agree that it was an impossible situation. Something that the petitioner is now trying to take benefit of, which we may not allow. True, what you are saying. But with the gaps, the benefit has to go to the any notice sent to a council regarding something through the Bar Association, does it suffice? Can it suffice? Please show us. That through the police, show us. That informing the police of the local thing. Where? Where are we reading? This one?
48.
You are asking us to interpret 48 beyond what Apex Court has done. Apex Court has said, do it in writing.
Yeah, so police officer in that last line of section 4.
And also,
Yeah,
that is also,
yeah.
then You see, then we have to read such arrest and place where the arrested person is being held to any of his relatives, friends, other persons as may be disclosed or nominated by the arrested person for the purpose of giving service, also to the designated police officer in the district of what? No, it requires a nodal officer to be appointed. Am I incorrect, Mr. APP? The requirement is for a nominated officer in each of the districts who can communicate. Is it not? For 48? Someone was making a submission that has not been done in the state of Assam. That is what is required. That is the district which is being talked of.
Cannot submit beyond that.
And I do not find.
Lordship is to up to your lordship.
Okay, heard Mr. So-and-so on a council.
Is there I place before?
We'll take record of everything. Heard Mr. So-and-so on a council appearing for the petitioner. Also heard Mr. SCKL on a council appearing for the NCB. Full stop. This is a bail application preferred by the writ petition, praying for regular bail in connection with NCB Guwahati crime number so-and-so registered under so-and-so. The petitioner has been behind bars since 24/6/2025. Full stop. The counsel for the petitioner has submitted that the petitioner had been arrested on 24/6/2025 on an allegation that certain amount of narcotics had been recovered from the conscious possession of the petitioner. The learned counsel for the petitioner has submitted that at the time of the arrest, the petitioner had not been made aware of the grounds of arrest as required under the provisions of section 47 of the BNSS 2023, and further that the friend / family / relative of the petitioner had not been informed of the grounds of arrest, etc. immediately upon the arrest. Full stop. The learned counsel for the petitioner has submitted that the non-communication to that is your only ground.
Then other ground is there that 0.153 kg was recovered, which is intermediate quantity, but they have recovered another quantity from co-accused which was traveling in the bus, and they have clubbed it together without there being any material for abatement or conspiracy.
Both the accused were related?
No.
They are not related.
Not related.
But traveling together?
In a bus.
In a bus?
That page 19.
In adjacent seats?
Or maybe.
What more connection do you need? Yes. Section 48, the counsel for the petitioner submits that violations of the provisions of section 48 of the BNSS 2023 has been held to be violation of the fundamental right of the petitioners under Article 22(1) of the Constitution of India, and therefore the counsel for the petitioner submits that the arrest and further remand of the petitioner stood vitiated. So he accordingly prays that the petitioner may be released on bail. Stop. The learned counsel for the petitioner has relied upon, what is this, Ahmed Mansoor?
Here, Lordship, it is said that substantial compliance will not do, that return has to be given, Lordship.
On the learned counsel for the petitioner has submitted that It has been held in the case of Vihan Kumar versus State of Haryana, reported as 2025 SCC Online, Supreme Court 269, that the requirement of informing the friend of the friend relative of the petitioner of the arrested person is a mandatory requirement, and not informing, where is it? Where is the part that it has to be done?
Supplementary judgment, Lordship, passed by Honorable Justice M. Koteswar Singh, Lordship. Paragraph 2 and 3. Lordship, man, condition.
The purpose is a mandatory requirement, and the mandatory requirement and violation of the same would render the arrest and further detention to be in violation of the law, full stop. The learned counsel for the petitioner has then referred to the judgment of the apex court in Ahmed Mansoor and others versus the state. Within bracket likhibo criminal appeal number 4505 of 2025, disposed of on October 14, 2025, to impress upon the court that the requirement is mandatory and substantial compliance would not serve the purposes of law. The learned counsel has thereafter relied upon the orders passed in bail application 3121 of 2025, disposed of by this court on 31/10/2025. Where under similar circumstances of non-communication to the relatives of the accused, this court had granted bail to the arrested person, full stop. Mr. Ezekiel, by reference to the records, this is the CD. By referring to the CD, has submitted that there is already by referring to the case case diary, has submitted that immediately upon the arrest, the petitioner was allowed to communicate with her elder brother over telephone, and simultaneously an email had been forwarded to the police authorities in Bihar to communicate with the father of the petitioner. The printout of the email sent is also available in the case diary, along with the written communication? Along with the written communication attached to the said email. That will do? Yes. The counsel for the respondents have referred to the case of Mihir Rajesh Shah versus State of Maharashtra, reported neutral citation being 2025 INSC 1288, where at paragraph 34, the Honorable the Apex Court has held that the objective enshrined in Article 22(1) of the Constitution of India for furnishing grounds of arrest stems from the fundamental principle of providing opportunity to a person to allow him to defend himself from the accusations that are leveled against him leading to his arrest. The salutary purpose of informing the grounds of arrest is to enable the person to understand the basis of his arrest and engage legal counsel to challenge his arrest, remand, or seek bail, or avail any other remedy as may be available to him under the law. at paragraph 42 of the aforesaid judgment, the apex court had held that the ground of arrest must be furnished in writing in order to attain the true intended purpose of Article 22(1). The learned counsel has also referred to the order dated 2/12/2025 passed in bail application number 3468 of 2025 to attempt to impress this court that in similar circumstances where the wife of the accused applicant therein was immediately intimated about the grounds of arrest of the accused applicant over phone, this court had deemed it to be substantial compliance of the provisions of section 48 of the BNSS. He accordingly praised that the bail petition be dismissed. We have considered the submissions made by the learned counsels for the contesting parties. In the present case, we find that although the respondents have asserted that the brother of the petitioner had been informed over telephone regarding the arrest of the applicant here, petitioner here in comma, there is no assertion made that the written communication had been sent on the WhatsApp number on which the brother of the petitioner had been communicated, unlike the situation that was prevalent in case of bail application number 3468 of 2025, on which the learned counsel for the respondents had relied upon. In the said case, this court, while observing that the wife of the accused applicant had been informed over the phone, it was also observed that the scanned copy of the notice under section 48 was immediately sent to her on WhatsApp in her mobile number, full stop. In the present case, this court also notices that though the petitioner was arrested on
24/6/2025,
and it is the assertion of the respondents that information regarding her arrest had been sent by email along with an attached copy of the notice under section 48 BNSS to the father of the petitioner through email addressed to police authorities in the Bihar Police, no record or statement has been made before this court that any efforts were made to find out whether such notices were actually served upon the father of the petitioner or not. This is despite time having been granted on at least 2 occasions to have instructions on the receipt of notice by the father of the petitioner, full stop. In view of the above, this court is of the view that the relative friend oblique, family of the petitioner were not effectively informed about the arrest of, about the grounds of arrest of the petitioner, full stop. It is an admitted position that the petitioner does not belong to the state of Assam, and therefore it was incumbent upon the respondent authorities to have ensured that proper communication of the grounds of arrest of the petitioner were made, full stop. Without commenting upon the made, full stop. The court also notices that the submissions made on behalf of the learned the court also notices the submission made by the learned counsel for the petitioner that an amount of 0.153 kgs of contraband had been recovered from the petitioner, and the same was
clubbed together
with recoveries made from another co-passenger to have the entire total amount brought to the level of a commercial quantity, full stop. Without commenting on the above, submission, comma, this court is of the considered view that due to the violation of the fundamental right of the petitioner under Article 22/1 of within bracket 1 of the Constitution of India, when the respondents failed to appropriately intimate the grounds of arrest to the family, friends, relative of the accused, comma, this court directs that the petitioner be released on bail on her furnishing a bail bond of rupees 30,000 with two surety. 50? Page 36. Okay. How much? 2 lakhs. Okay. Bail bond of rupees 2 lakhs. We'll keep it the same. Bail bonds of rupees 2 lakhs with two sureties of the like amount, one of whom shall be a government servant and residing within the state of Assam, to the satisfaction of the learned trial court, subject to the following conditions. Page 36. Baki ki the condition. These are the conditions you want. Anything more? Full stop. The learned counsel appearing for the NCB has submitted that there is probability that the notices on the father of the petitioner had been served appropriately, and it is only the failure to produce the relevant documents as of today. Full stop. In case the notices as required under section 48 had been submitted upon the father of the petitioner, comma, the respondents would be at liberty to move appropriate application to bring the same to the notice of this court. Stop. Bail application disposed of. When the liberty of a person is concerned, a little more effort has to go in. Since
Subsequent.
that subsequent is what? No, what we are just suggesting is when the liberty of a person is sought to be thwarted by agencies who have got some little extra reputation, then they have to go that extra mile to see that the reputation is maintained. Otherwise, usual local cases, it's a different thing. But when the agency is more reputed, the effort has to be more. It has to go up by degrees. Mati to tomorrow. It'll have to come up day after tomorrow. This we will have day after tomorrow. We have not been able to complete the whole thing with the printout and everything. So we'll have it day after tomorrow. Let's list this matter again on day after tomorrow. এইখন আছে নেকি সুধকচোন তাৰমানে এই বস্তুটো লাগি ধাৰটো লাগি থাকে yes
Lordship, I have been informed that CD is not received.
Who informed you? That is one interesting question. Who informed you? Did the APP inform you?
Yes.
You informed? It is submitted that the case diary in this matter is yet awaited. The petitioners are under interim protection of this court. List this matter again on 29th of January 2026 along with the CD. Let's save some time for the court because in the morning also we can.
Lordship, interim may continue.
The interim order, the interim protection to the petitioner shall continue till the next date of listing. Listen to interim order. On 29th, I'm not wrong, 29th. Yes, it's 43. What did he do?
Your Honor, this present petitioner is not named in the FIR. The name accused was arrested and everything was seized. Because the name accused was the brother of this present petitioner, therefore police is searching for him. He's working in a consumer service point of SBI in Batomari. So in case of any arrest,
Yes, anything to trouble the brother?
there is nothing against him.
No, there is all right, but are you under interim protection?
No, Your Lordship.
Not under protection. Working somewhere, he's working inside the bank. The allegations are that the brother has been defrauding people. Huh? Paishan kya nahi? What happened to
There is nothing against him in the forwarding report and the FIR itself also, and also the accused.
Why do you apprehend? Any phone calls made to you?
So he is the brother of the arrested accused person. And the arrested accused person is also arrested on suspicion, Your Honor, as per the forwarding report itself.
Was it huge cases? What does your brother do?
They have business, Your Honor.
What does the brother do?
Brother have business, and relating to these offenses, he has nothing to.
Business,
These are fishery business.
Huh?
Fishery business.
Fishery. Yes, from when has this amount become a very large amount to be arrested? Have you seen page 12? Kindly see page 12. That last, the second last bullet, no, the second bullet under grounds of arrest. There are bullet points made, no, at paragraph 12 towards the end. Second one, from when has this become an amount so large that a person should be arrested for possessing that amount? So large a cash amount. Huh? Anyway, we are not looking into the brother right now. He can go appear before the investigating officer. So he can go and he can make his statement that I do not know anything or I know everything. Friday. Whether his presence is required or not. What do you say? Friday? It will be on Friday. Heard Mr. So-and-so and a counsel appearing for the petitioner. Also heard Mr. So-and-so and a learned APP, comma. The learned APP has paid for this matter to be listed on Friday, by which time he would have instructions as to whether the investigating authorities would require would be required to investigate into the activities of the petitioner herein, who claims to be the brother of one of the arrested accused in so-and-so case number, huh? Case number, Naga PS case number so-and-so, huh? Case number 2 does. And the case diary had already been called for, which is not received. The learned APP shall also make an endeavor to have the case diary collected. Otherwise, prima facie, we think the brother, he can go and make a statement if he is not involved in the business. That is my prima facie view as of today. unless he has been printing the notes. Yes.
May please, Your Lordship. It is that material is listed on 812, that owner of the escape material go down.
Huh?
Yes,
Oh, yes.
I am the owner of escape material go down, Your Lordship. I have visited. I am not in the name affair, Your Lordship. Page 12 is the affair. Your Lordship, interview was not granted, but CD was called for, Your Lordship. Use the and that
Oil materials were there, therefore. Mm. Mm.
now escape material my go down is ours, but nothing is.
He is just a usual scrap material dealer. Material has not been recovered from his premises. But because these people they sell the scrap and everybody is rounded up, he is under an apprehension. Apprehension we appreciate. What to do with the apprehension? Does your CD allow him to be considered?
No, other also go down also. Other ground also they have visited here.
Well, what is the other ground? Someone visited the premises.
Your Lordship.
Oh yes, his
That
godown has already been
already
searched.
visited, nothing is recovered, Your Lordship. In absence
Nothing
of my-
recovered. That is his allegation.
And that person.
Can you go and make a statement? Huh? By the time you have the CD, because this order was given on
8.
8th.
12.
Heard Mr. So-and-so and council appearing for the petitioner also heard Mr. K.K. Parashar and APP. Instead the CD call for the CD as called for by the order dated 8/12/2025 is yet to be received. The allegations in the FIR are to the extent that some material of the Oil India Limited had been collected by some unknown person and who fled away in a nano car. That is what? Nano car, full stop. The petitioner who is a scrap dealer is apprehending arrest by the by the police authorities since his top premises have been raided, although nothing has been recovered from the said premises, full stop. The petitioner is directed to appear before the investigating officer in
Naharkotia, please.
Naharkotia PS case number 64 of 2025 within a period of 5 days from today. It is provided that in the event of his arrest, he shall be enlarged on bail of rupees 10,000 with one surety of the like amount, subject to the satisfaction of the investigating authority, and on such conditions as the investigating authority may deem fit. Full stop. The CD produced on the 30th of January 2026. Stop. Further continuance would be would depend upon the materials on the case diary.
Obligation.
Yes, madam.
Please, Lordship. Lordship, service upon respondent number 2 is completed.
Who appears? Appeal. 3042.
Yes, completed, Lordship, 2 years, 2 months, and 15 days in jail.
How much was he sentenced with?
4 years, Lordship, under section 304, part 2.
50% gone.
Yes, Lordship.
More than 50% gone. Yes, sir. Huh? But where is the IA?
Here is I.
There is an IA.
Yes.
An IA আছে বলে দিয়েছো। IA আছে নাকি?
মোৰ তাত আছে extra, আপোনাক মই দিব পাৰিম।
Wife does not appear to be in the location. No, I'm just going through the judgment. The wife was not at the location of the fight.
Wife was the informant, Lordship.
One kick. What does the postmortem report say? What kind of injury was there in the stomach? Conducted the postmortem. Yeah. Mr. Parashar, brother-in-law, over a drink, 80 rupees was demanded, 60 was given, 20 rupees was kept back. I am your brother-in-law, let it go. Pushed, kicked.
Kicked.
Person did not drive from the kick. When he fell down, he suffered hemorrhage. Can it be said that he had the knowledge or intention that a push would make a person fall and... This was just a push. Is it not? And not with the intent of having the head hit on the ground to the extent that there will be a cerebral hemorrhage inside.
But there was no swelling.
No?
No swelling in his head. And
But
he's
that
not.
is after the pushing. We are on whether the intent and the knowledge was there. Kindly understand, madam, we have to find out whether the intent to give a push which will
The
kill.
accused stated in his 313 statement
What
that
did he say?
there was a gentle push.
Yes, what do you say? I think we can go for a disposal
And
on
that
this.
kind of push, he won't.
I think we can go for a Intention is not, even knowledge is not there. A
Knowledge
push
is not
between
there.
brother-in-laws.
There. Yes, Lord.
Will it lead to death? Can anybody think that I'll give a push and someone will die? No, but unless you want to go for a full hearing, we'll keep it CAA. We'll pass the orders by the end of the week. Up to you. If you want to do a full hearing, we'll keep it for January or February. That's otherwise. Otherwise, if you think that no, the circumstances do not, he has undergone 2.5 years. Brother-in-law, not even that friends or not even that acquaintances in a wine shop trying to go into a brawl. Over a 20 rupees, one person pushes the other. Intent, knowledge, we don't find anything. Yeah, we'll close this. What do you say? 2 years gone on one push. Loss of family. Sister making a wife making a complaint that my husband is killed. Too much. Too much. Yes, what do you say?
And he was an epileptic person also. And the diseased.
Do not say all those things. Then the knowledge will come in. Do not say all those things. Disposed of. Appeal allowed. CAV. Appeal allowed. Allowed. Allow this. CAV, yeah. এটা allowed লিখি থৈ দিব order pass কৰি দিম yes
Your Lordship, appeal under the NDPS Act 20B2B and 25. Today I am here for the IA itself, Your Lordship, not the appeal. So, Your Lordship, there are serious non-compliances and infirmities in the entire prosecution story. So, I pray that a date may be fixed after Christmas vacation for the IA to be heard, Your Lordship, at this stage. Yes, Your Lordship. In that time, they can file their objection. All the records from the trial court are annexed in the IA itself, Your Lordship, so there won't be any difficulty.
The learned counsel for the petitioner has submitted that all the records of the trial court. I have you next certified copies of it, no? Oh, the TCR is available and the matter may be taken up and the IA for the interlocutory application may be taken up on a date immediately after the vacation for consideration. Learned PP has also made a similar submission. Stop. Let this matter be listed on the ninth of January. 9th of January 2025 or 2026 for consideration of the IA. Learned APP may file objections in the meantime. Yes.
Under POSCO Act, my lord, TCR has not been received, my lord. I have checked the office note. Service is not complete.
What are your grounds otherwise?
Grounds, my lord.
It has been submitted that the trial court records are yet to be received. List the matter again on
After vacation. Second week of January, my. Sorry, second week of January, my.
a little beyond that perhaps. 20th of January. We'll keep it at 20th of January. Oh. ইয়াতে দেখুৱাই থকাটো শুদ্ধ বুলি ধৰি লৈছো আৰু মই হা এই again ক'ত আছে হা ওপৰ সিলেক্ট কৰিব লাগিব already login anyway what did I say 20 recycle 20th 20th 20 January huh option 20 January to লিয়ে সব ভুলিলো নেকি 30 তাৰিখে 13টা দেখুৱালে জানো আৰু এটা যাব আৰু খুব বেছি অনি দিম এটা 20 টো ব্লক কৰি দিম yes 20 January yes TCR not received madam yes
The service report in
the scan copy of the PRC case number so and so along with the scan copy of the case diary of Belsor PS case number so and so are yet awaited. Full stop. List this matter again on Hmm. Twenty-first of January, 21 January. The registry would issue reminders for the scan copies as called for in the earlier order.
49.
Bless the Lord.
Yes.
My lord, 528 application, my lord, seeking quashing of the FIR and the charge sheet. My lord, on the last occasion, your lordship had called for the scan copy. That has come, my lord. It has received, my lord, in the court. It has been received. Court would receive. The last file. The allegations made in the FIR and the charge sheet, even taken in its entirety, do not constitute a criminal offense, my lord.
Yes, sir. Even if the respondent has to appear.
He has to appear, his notice is returned unserved. So we have sent to the same address which has been mentioned in the FIR.
Oh, you were yes.
There is another file, my lord, another outer files.
Insufficient address returned to
It's the same address given in the FIR. Otherwise, we can do one thing, my lord. We can send the copy to the company, which is in Amingaon. The employee has filed.
The employee has filed it.
You can send it to the company, my lord. I have the address of the company.
Mr. Spencer on a council appearing for the. This one is the LCR.
LCR has come. TCR has come.
It's not supposed to be said LCR now, no?
TCR.
Huh? They also, our court is writing LCR. The counsel for the petitioner submits that although steps had been taken on the address of the respondent number 2 as given in the FIR, but the office note reflects that the same have been returned back unserved with postal remarks insufficient address returned to sender, full stop. The scan copy of the case record of PRC number so and so has been received. Full stop. The counsel for the petitioner prays for the liberty to serve notice upon the informant, respondent number 2, through the company for which in which he works and on whose behalf the FIR was filed, comma, whose address is given at where is it to the company?
Separately, my lord.
Huh?
I can give it separately.
You had sent it on this address, Triangular Colony, Jalukbari. Okay. At the address given in the memo of parties. Full stop. To expedite the service of notice on respondent number 2, petitioner is allowed to take steps on the respondent number 2 at the address given in the memo of parties, which is stated to be the address of the company. Full stop.
My lord, is the address of the person concerned.
By speed post, huh?
From where it has returned unserved, my lord. It's the same address. Parties, the address given in the name of party. It's the same address where we had sent the earlier letter.
So where do you now want to send it?
Now I want to send it to the company. It is at Amingaon. I have the address. I can give it separately.
That address you have not given till now.
It's not.
Then you have to change the order, huh? To the address which would be of the company in which the petitioner serves and which will be supplied by the petitioner. Full stop. Liberty is granted. Petitioner to take steps on the address to be now furnished by him before the registry within a period of 1 day. এইটো কেছতে ন PCR of what song? Case record kiman song? PRC case number? PRC number, what is the PRC number?
My lord, 313, my lord.
313,
PRC number 313. pending adjudication at the learned CGM, Kamrup at Amingaon.
Um, it has been submitted that the cause list does not reflect that the TCR has been received, although the TCR is on record.
I pray that the interim may be granted, my lord.
Huh?
That next date is on 24/12, my lord.
Huh?
I pray for interim order, my lord. Stay of the proceeding, further proceeding.
On the, what is the stage on the next day?
A notice has been issued for appearance. For appearance of the accused.
The petitioner is given the liberty to inform the learned trial court regarding the pendency of this criminal petition for consideration of fixing an alternative date beyond the date fixed by this court for consideration of the criminal petition. Stop. List the matter again on. List this matter again on. Date dilu niki kibara? Ahead on 3rd of February. On 2nd of February 2026. Why don't you serve? That we'll do on the, we can do on the next day. You can serve him through the trial court also. Because he would be coming, the informant would be there. Next.
May it please your lordship.
Yes, sir.
Your lordship, I'm challenging the order dated 4/7/2024, page 33. Your lordship, may kindly peruse the order. Aggrieved Anu Kumari Singh has filed a petition under section 120 of the PWDV Act seeking relief under section 18, 19, 20 and 22 of the Act. Against the respondents, namely Rahul Sai and Sakuntala Sa. The petition is supported by an affidavit registered. It is a DV case. Call for the DIR. Issue notice to the respondents to show cause why relief sought by the aggrieved should not be granted against them. The aggrieved shall take steps. Fix 9/8/2024 for DIR appearance written statement. Now, your lordship, the Act, if your lordship may kindly take up the Act for a moment. The Protection of Women from Domestic Violence Act 2005.
That's it. Domestic violence. And yeah. Bogart unit. I thank you. Yes.
The lordship may kindly peruse page the section 12.
Section 12.
Section 12.
Yes.
Application to magistrate. An aggrieved person or a protection officer or any other person on behalf of the aggrieved person may present an application to the magistrate seeking one or more reliefs under this act, provided, lordship may kindly note, provided that before passing any order on such application, the magistrate shall take into consideration any domestic incident report received by him from the protection officer or the service provider. Now, in this case, your lordship, this particular shall is a mandatory provision, and in spite of
So the section 12 is a bar.
there is a bar, your lordship.
That unless you go before the
No, unless an order, yes, your lordship.
unless someone goes before the protection officer or the service provider first, they cannot come to file an application.
Exactly, your lordship.
Is that your interpretation?
Yes, your lordship. Before that is the provided before passing an order on such application, the magistrate shall take into consideration any domestic incident report. Now, the domestic incident report is very important, your lordship. Here in this case, the learned court, your lordship, had passed an order by which the domestic incident reports was called for, but it was not taken into consideration while passing the order. So,
It was there.
yes, your
The
lordship.
report was there.
Yes, your lord. No, it was not there, your lordship. It was not considered. No, it was not there.
That is what I'm,
The
that
court-
is,
yes,
that is, that is what is disturbing this code. If we
Yes, yes.
today hold that under section 12, until the person first approaches the protection officer or the service provider, he will never be able to approach the court. Can we bar it?
Because your lordship, in my respectful submission, this
If there is a report, that shall be taken into consideration.
Exactly.
But if there is no report, if the person rushes to the court without approaching the protection officer,
But
then
that
what
is-
happens?
That is my respectful submission. They have to go to the protection officer first, your lordship. That is what is mandatory, your lordship. It's a
No,
mandatory
this-
provision. They have to
Then
go
the
to the
entire
protection officer.
protection part goes, it becomes a procedural part.
No, your lordship, it's a mandatory
Huh?
provision, your lordship.
Then you are asking a victim and an alleged victim to first go take the rounds of.
In my respectful
It will be
submission.
like saying that you cannot file a complaint before the magistrate without first trying to lodge an FIR. Without lodging an FIR and a police report being there. You cannot go to the complaint.
I understand, your lordship,
Yeah.
but that is the provision. Because it has been written shall, it is not may. So it's a
Yes, sir.
mandatory
What do you say
provision,
you
your
are
lordship.
applying for?
And answer why.
Huh? You want to file your objections?
No, objection. For my lord, to my. I feel lies.
May I submit a judgment?
Judgment is there. My own case.
That is what we have been trying to also convince other advocates. Judgments are of the court. There is no use of taking names that so and so judge has given this judgment. It doesn't matter. The judgment is of the court, sir.
First protection of the report. Report will come later on. Court will ask for the protection officer to report, my lord. If report is adverse, then case will go. If report is favorable, case will remain.
Oh, yes. So one can approach the court, but the report has to be called for. That is your stand.
Exactly. That is my.
So I have approached, report has been called for, let the report come and ran away before your lordship. So there is no.
Who has called for the records?
So?
Court below has not called for the records. Where is it? Where is it that order you are reading us?
Get that far.
Where is it?
407, your lordship, page 30.
Just a minute. Are all the orders here, sir? 25-6.
15
Case record received.
It did not appear,
Huh?
but your order was vacated.
Which order, ex parte order?
Page 37, can you see?
Just a minute. Aggrieved so-and-so has filed petition under so-and-so. Register a DV case. Then 4798. Endorsement so-and-so refusal amounts to acceptance. Respondents are absent without SIP. Hence case will proceed ex parte. Fixing ex parte. Fixing 13.9. Then, 13.9.
I appear, your lordship, the ex parte order was vacated.
1510. Aggrieved woman is present. They had no legal person. They couldn't appear. Yes. Yes, where is the report called for, sir? You said report has been called for by some order?
There was no, the report was there, your lordship, from 4/7/2024. Then your lordship, they may kindly peruse page 34 for a moment. There is 9/8/2024.
20?
34, your lordship, page 34. Just 3/9/8/2024. Aggrieved is present. Notice to the head, your lordship, got it?
Yes.
34. The aggrieved is present. Notice to the respondent is returned with the endorsement on post that the respondent refused to receive the same refusal amounts to acceptance. Notice to the respondent is deemed to be served. The respondents are absent without step. Hence, the case will proceed ex parte, fixing 13/9/2024 for ex parte evidence.
Will this do? Will this order do?
No, your lordship, in my yes, your lordship. Yes, your lordship.
Have you gone through this order,
That
sir?
order may be passed.
No.
It may be disposed of, your lordship.
We'll take it up after some time. Kindly go through this order. Deduction, sir.
There is time to file objection.
Just go through the order. It will shorten the length of agony for both the parties. After some time, Mr.
Yes,
Devi.
your lordship.
You have
Yes,
taken
sir.
steps. Well, on the office note, it transpires that service upon respondent number 2 and 3 is not complete. Yes, but their bank official, we have taken steps twice, but no answer notice or ID card has been returned back. So may I pray for listing of this matter before the LOSIMA so that nowadays register post can be tracking result can be obtained from.
Nowadays, you have to take it by speed post.
Yes.
Register post was gone by the time 18/9. Yes, no, 1st of October,
Yes, yes.
speed post লাগিছিলে to.
Just prior to that, we have taken steps by registrar. Even registrar post.
The office note dated 12/12/2025 reflects that neither AD card nor any unserved notice in respect of respondent number 2 and 3 have been received back by the section, upon whom notices were issued by registered post on 18/9/2025. Full stop. The Learned Counsel for the petitioner has submitted that the matter may be listed before the Law Azima Court for a complete report on the status of the service. Full stop. Ms. So-and-so appears for the respondent number 1. Stop. Place this matter before the Law Azima Court within a for the Law Azima Court. When? On 6th of January 2026. Full stop. Yes, prayed for by the Learned Counsel for the petitioner.
I always.
May I plead the lordship?
Yes, sir.
I am husband petitioner and my monthly income is rupees 6,500. That is reflected in the order itself, and I have also annexed the certificate. Kindly see page 62. This is the certificate given by my employer. This is certified as Nur Hussain, Ali son of so-and-so. So-and-so is holding the position of sales boy in Shah Electronics and has been getting rupees 6,500 per month as remuneration. He has employed with us since 2021. So, my lord, my income is 6,500 and the learned court has given 8,000 per month to my wife. And the wife is also earning rupees 1,500 per month, she has admitted. And she went to her father's house without my knowledge with her father. I tried my level best to get her back, but she did not come and filed 4 cases against me. 4 cases.
Are pending?
Yes, still are pending. These cases are pending. Only to harass, and she has also sent messages that I will harass you like anything. Those messages we have annexed here.
Where?
Lordship may kindly see the messages. 14. Yes, page 14 kindly see.
1/4.
1/4, yes. 1/4. It is type copy. That is 14. I have filed false case only to harass you all. I will file more. So I will then, I will be filed. You did not come to bring me. I will file more. What you do think, I will file more by making false. Yes, we are shameless. So these are the originals. We have annexed page 15. So her motto is to only to harass me, not getting the maintenance. And she has made my life miserable from all direction. Now, my lord, last page 14, last kindly see. I know you do not take back me, and I also do not go now. I have been filing the case only for harassing. So these are messages. Kindly see her motive and intention. And now, my lord, the Supreme Court says at least 25% of the salary may be provided to wife. And to that effect, I have judgment also. Kindly see.
No, the thing is that after when the order of the maintenance was passed against you,
Yes.
you did not bring on these records because the
No.
order was passed on October,
It is
and your
reflected.
certificate is of
letter, but
November.
It is reflected in the order.
Go and you approach the court saying that, look, this is my certificate. I cannot pay this much. Please reduce the amount.
It is reflected in the judgment.
Yes, that you made a statement. The statement was not believed.
Then, Lordship,
Now you have proof.
kindly dispose of this matter.
Now you have proof. You can go and
you have no
ask.
objection.
Huh?
We have no objection. If your Lordship observe that.
Yes.
Very exceptional last. On 7/4/2020.
Ah.
I have been driven out from the national award in 2022. So, the losses, I have been compelled to leave the national award.
Hmm.
Up to 10,000 rupees.
In the which settlement?
Because you lost it, once you driven out, you lost it from the house. Last time you lost it 10. So far was 10,000 was again demanded.
Oh, they demanded 10,000 from you, you paid 10,000. Acha, then?
Because again, he never tried to bring it back in office. So,
Hmm.
and neither he himself tried to lose it, or any of his.
Have you gone through that Supreme Court judgment where it is said that reasons for arrest and grounds for arrest are two different things?
I have only two reply.
Have you gone through that? Reasons and grounds are two different things. So arguing on merit and making general submissions are two different things. We are running short of time. General submissions, forget it. Tell us something with regard to the case.
Lost it, because on both sides you lost it.
When did you enter appearance?
Tax also you lost it.
Hmm.
6,500 rupees is not in loss.
He is the employer. Go and report for duty.
Because nowadays even for a you lost it.
Yes, we are.
You lost it, kindly look into page 50, lost it, para number 3 you lost it.
Yes.
So in my plan as well as you lost it, it's also reflecting the government.
Hmm.
Opposite party has a mobile showroom. That's a good cultivation of reason. Also earning from as his monthly more than monthly maintenance of 40,000.
This is your statement. This is your statement. This is your evidence. This was your evidence, or this is just your statement in the complaint?
I have said you lost it, but she has sufficient source of income. It's not that you lost it, he has been. That's why you lost it, brings this. On record you lost one test.
This is the final judgment.
This is the final.
Where is that affidavit? Your assessment liability affidavit,
We
sir?
have filed the affidavit, but it is not reflected in the, but we have annexed here.
Because.
We have annexed here the affidavit.
So what the assessment liability.
Where is your affidavit? Did you file an affidavit of asset and liability?
Asset liability.
He has to. Order, nothing has been reflected. We are setting aside that order, it goes back, they will take, the learned court will take into consideration.
I have two replies only.
Ah.
My learned friend says, if she wants to go, still I am ready to accept her with any condition, number one. Secondly, my lord, let him say that these messages are not sent by her. Let him say before the honorable court.
The messages are sent from her mobile, not by her. That is the
Mobile.
reply. Yes, take down.
And that is second marriage also you lost. Then not waited for me you lost.
No, please wait.
With the kind of messages which have flown and which you have not disputed. It is not even accepted, no?
That's it. Not accepted. Then it may be observed, my lord. Then let her phone be subject.
Not admissible, that's why not.
Yes, just a minute. He has not proved that he has limited source of income and he has no landed property. How can you prove that you don't have any landed property? Kindly tell us. How can someone prove I don't have this? Can someone prove that? I don't have property. How can I prove that? No, I'm asking that the court has written petitioner has not proved that he does not have property. How can the negative be proved, sir? He has property can be proved. He does not have property. How do you prove that? I am the petitioner. How can I prove that I don't have property if I don't have property? Can I prove I am not the owner of Taj Mahal? I cannot. It's a negative proof. How can I prove the negative? Heard, Mr. So-and-so also heard. Just so-and-so Learned Counsel appearing for the respondent. We are sending it back. Let her consider the.
Lordship, one thing that can be reflected in Lordship.
We will leave everything. So this is a revision petition. This is a revision petition assailing the impugned judgment and order dated 29/10/2025 passed by the learned Principal Judge, Family Court number 1, Kamrup, Guwahati, in FC Criminal Case number 64 of 2024, whereby the petitioner has been directed to pay maintenance allowance at the rupees of 8,000 per month to the respondent from the date of filing of the petitioner, and the arrear amount be paid within 6 months from the date of the judgment. We have heard the learned counsel for the petitioner and the respondent number 2. And the sole respondent, full stop. A perusal of the judgment dated 29/10/2025 reveals that the learned trial court below did not take into account the affidavits of assets and liabilities filed by the contesting parties while determining the quantum of maintenance to be paid and to which the respondent may be entitled to. Full stop. This is a flaw which would render the very quantification to be to deserve the interference of this court, full stop, without reference to any other observations made in the aforesaid judgment, comma, the order dated 29th day of October 2025, in so far as it quantifies the entitlement and the liability, entitlement of the respondent and the liability of the petitioner to pay a specific amount of maintenance is set aside, full stop. The matter is remanded back to the learned trial court to reassess the maintenance that is required to be paid by the petitioner to the respondent number 2 on the basis of available records, including the affidavit of asset and liabilities filed by the contesting parties, full stop. Criminal petition is disposed of.
Petitioner allowed to file his salary certificate.
Both parties would be at liberty to adduce such evidence as may be necessary to justify the statements made in the affidavit of asset and liability.
Obliged.
Go, you show there what is your liability, what is your asset. Let it be considered in the true light. We are not interfering in anything. Were you getting any interim maintenance during the pendency? The learned trial court may also decide on the quantity of interim maintenance required to be paid during the pendency of the case now being remanded back, full stop. The learned trial court may make an effort to finalize the matter within a period of 3 months from the date of receipt of the record. Kini gusi ahisile niki? Record kini ahise niki logot nai hato record? Et logot record aha nai ko? Huh?
No, that is not. That is set aside.
We asked you very specifically, were you getting any interim maintenance? Had you given us the amount, we would have recorded it in the order that this was the interim maintenance which shall be paid during the period of remand. You did not tell us anything. Yes, next, huh?
For hearing item 51.
No, interim has
As per our information.
order to pay. If you file a petition,
You
then
file a
we provide.
petition, you will be paid in interim. We have provided for that. Yes. এটা আছে হিয়াৰিঙত আছিলে এইটো লাষ্ট মেটাৰ নেকি এটা টাইম বিং আৰু নাই উফ Could we give them a jolt? Huh? We give them a jolt. Who are the consuls? A. Sharma. And from 2016, this matter has never come up again. Hmm? What is the check amount? 75,000. And fine of 1 lakh. The year 2008. Fine of 1 lakh. And in default, imprisonment for 6 months. And I
That has been settled also between the parties.
Huh?
Might be, it is might be.
Yeah, we'll close it. This matter relates to this criminal revision. This petition will appoint an amicus. This criminal petition, a revision petition, has been filed in the year 2015, assailing a judgment dated 31/10/14, passed by the learned additional session judge Nagaon in criminal appeal number 86 of 2012, affirming the judgment and sentence dated 11/10/2012, passed by the learned JMFC Nagaon, convicting the petitioner under section 138 of the Negotiable Instrument Act and sentencing him to pay rupees 1 lakh as compensation to the complainant in default to undergo simple imprisonment for 6 months, full stop. By order dated 2/3/2015, the aforesaid the operation of the aforesaid impugned judgment and order was kept in suspension, full stop. This case was earlier listed last on 22/2/2016, and thereafter it was listed on 17/11/2025. Stop. Today none appears for the petitioner on call, huh, sir? Today none appears for the petitioner on call. In view of the circumstances, this court appoints, yes. Please come. What is that list of amicus? you had given us? One. 7 নম্বৰ জন কোন হয় সব নাই নহয় 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 আমাৰ সিঙ্গল বেঞ্চৰ 7 নম্বৰ জন দি দিও তলৰখিনি সিঙ্গল বেঞ্চ না 7 নম্বৰ কোন হয় কুমাৰ DK Bhattacharya as amicus curiae in the matter to assist the court list this matter again on 20th of January 21st of January 2026 disposal.
Regarding item 50.
Yes, sir.
The report is there in the record.
Huh?
Report is there in the record.
Is there in the record they are seeing? You are
Your
there.
Lordship, if I may submit.
There was a report. Then even in that case, that report has not been reflected in the order.
Exactly.
So if the matter has to go back, all the trial court has to do is take into account that report and pass orders. If the report reflects anything needed to be taken cognizance of, cognizance will be taken. If it is not required, it will not be taken.
Exactly, Your Lordship.
That will do. We don't need to keep this pending is what I'm saying. We do not need to prolong the agony here. Heard Mr. T. Dury, learned counsel appearing for the petitioner. Also heard Mr. S.C. Biswas and Mr. Swens, assisted by... Huh? Okay, we'll record his name. Also heard Mr. Swenso. Your name? Yes. Learned counsel appearing for the respondent. Full stop. Mr. Deuri, learned counsel appearing for the petitioner, had submitted that the learned trial court had taken had issued notice in the case filed under the provisions of the Domestic Violence Act without referring to the report of the what we call
Protection
it?
officer, Your Lordship.
Protection officer and or the service provider, and therefore it was a submission of Mr. T. Dury that the aforesaid order requires the interference of this court. He had referred to the judgment dated to the order dated
2910.
so and so passed in it.
Criminal petition number, Your Lordship.
Criminal petition number so and so, where in similar circumstances the matter was remanded back and the impugned order issuing notice was interfered with and the matter was remanded back to the learned trial court to take into account the report of the protection officer and or the service provider before coming to a conclusion whether the notices are regarded to be issued or not. In the present case, Mr. Biswas appearing for the respondent has submitted that in fact there is a report of the protection officer available in records in the trial court and full stop. However, he concedes to the fact that the impugned order does not reflect that the said report had been taken into consideration before issuing notice. Full stop. In the facts and circumstances, as fairly admitted by the learned counsels for both the parties, this matter is remanded back to the trial court, to the Judicial Magistrate First Class, Kamrup Metro. As considered to be the learned counsel, as considered by the learned counsel, fairly considered to be the learned counsel for the parties, the order dated 4/7/2004 and 2024 and all other consequential orders are interfered with and the matter is remanded back to the learned Judicial Magistrate First Class, Kamrup, within bracket Metro, to take into account the report of the protection officer stated to be on record, and if no such record is if no such report is available, to call for a record from the protection officer and thereafter decide the requirement of issuing notice or other notices to the petitioner herein. Full stop. Accordingly, this criminal petition is disposed of, no costs.
I'm very grateful, Your Lordship.
Yes. Okay, done. Thank you.